Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Scheck, Mr. Bailey, Mr. Douglas, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. The jury is not present. Counsel, before we resume with the jury, I thought I would advise you of two things. I'm going to advise the jurors as to the nature of the delay that we had yesterday, what caused it, and give them my reassurances that that difficulty will not occur again. Also to advise you that it is my intention from time to time to inspect the jury facilities, either on their holding pen upstairs or at the facility where we have them housed, to make sure everything's okay. And I'll advise you ahead of time before I do that, but just to let you know I intend on doing that from time to time. All right, Deputy McNair, let's have the jury, please. I'm sorry, Mr. Darden.
Before you bring the jury out, the court please consider giving once again the 1.02 instruction indicating to the jurors that statements of counsel.
No, that's
not
part of my
evidence.
standard,
Okay.
not rereading, but just reminding them of that fact.
And with regard to the exhibition of the defendant's knees, will the court also advise the jury that that exhibition is not evidence?
That's understood, and I'm sure Mr. Cochran will mention that to the jurors at the time he thinks that's appropriate, and he's also, I'm sure, advised the staff as to when that's going to happen.
I missed the last thing here.
As to the exhibition of the knees,
Oh, yes, sure. It's not evidence.
yes, also the fact that you'll have to give the bailiffs advance notice.
No, I've talked to Deputy McNair, Your Honor. We're prepared on that. Your Honor, one thing that I did want to show also, if I could, is there is a mark on his middle finger also.
The one that was displayed by the prosecution
Yes.
yesterday? Yes.
Okay, those two things I want to, not have any surprises for the prosecution.
Will there be a 352 objection to that? What is the relevance of a scar on his finger today?
Oh, I think I'll link it up, Your Honor.
All right.
Is that an offer of proof? I think I'll link it up.
It's an offer of proof. Thank you. All right, let's have the jurors, please. All right, thank you, counsel. Thank you, ladies and gentlemen. Be seated. All right, good morning again, ladies and gentlemen. Record should reflect that we have now been rejoined by all of our trial jurors. Ladies and gentlemen, let me just give you a brief explanation as to what occurred late yesterday afternoon, just to put your minds at ease and so that you don't speculate as to what the problem was yesterday. Yesterday afternoon, the television camera that is mounted above you swung and inadvertently took a photograph of one of the jurors in our case, and that was brought to my attention, and what I needed to do was immediately get from the personnel operating the camera an explanation as to how that occurred, and to find out what measures would be necessary to prevent that from happening in the future, because if you recall, when we started this trial, I told each of you, I gave you each my promise that you would not be photographed or in any way represented to the public by way of picture. And so I was very concerned by that report, so I had to take immediate action, and that's why I felt it was necessary for me to stop the proceedings until I could be assured that the problem would not reoccur. I've discussed the matter with the juror whose picture was taken, and we've resolved the fact that there appears to be no problem at this point. It was less than a second that the juror was actually depicted, so it was a relatively minor transgression, but it was something that I felt was serious enough as far as your welfare is concerned that I had to take the time to do it. So I want you to understand that I was interested in your welfare at the time, and I'm sure you understand the need. Unfortunately, it also stopped Mr. Cochran from immediately beginning his opening statement, and on behalf of the court and the court TV, I apologize to defense counsel for that delay. All right, we will now start with the opening statement made by the defense. Let me just remind you that any statements made by the attorneys during the course of their opening statements, of course, is not evidence, should not be considered by you as such. It's merely an explanation as to what they intend to prove or what they think the evidence will show you during the course of this trial. Mr. Cochran, on behalf of Mr. Simpson, are you prepared to proceed?
I'm ready to proceed, Your Honor, and thank you very, very kindly. Morning, Judge Ito, my colleagues on the right here, the prosecutors, to my colleagues on the defense side, to the Brown family, to the Simpson family, to the Goldman families. Ladies and gentlemen, good morning to you. As the court indicated yesterday, I would have liked to have had this opportunity about 3:30 to address you. And it's my opportunity and it's my honor and privilege on behalf of the defense and our defense team, as it were, to stand before you now and address you what is called opening statement. Now, the opening statement is not opening argument, but it's just that, opening statement. If you've had occasion to go to a movie, you know that there's something called the previews of coming attractions. And that's what this is supposed to be. It's supposed to be a guide, our roadmap, if you will, what we expect the evidence to show. As an officer of this court, and in the course of my remarks this morning and maybe this afternoon, I would expect to tell you as honestly and as forthrightly as I can what I expect the evidence to be. As the court has so appropriately indicated, what I say is not evidence. It's just to aid you and guide you. I hope you remember something else the judge said to you last night. You heard the prosecutor's opening statement yesterday, that you were the same admonition applied to them. Those were not facts. But you kept an open mind, because you promised to do that throughout. We started this process of trial back on September 26th, 1994. That was the first day we all met, when you came down to that jury room up on the 11th floor. And here we are now, several months later, in this search for justice. You hear a lot about this talk about justice. I guess Dr. Martin Luther King said it best when he said that injustice anywhere is a threat to justice everywhere. And so we are now embarked upon this search for justice, this search for truth, this search for the facts. Each of you made a number of promises in the course of the voir dire examination, which is basically unprecedented and due mainly to the largesse of Judge Ito in understanding the possibility of media taint associated with this case. So we know a lot about you at this point, and we, of course, all sides are very, very pleased with the fact that you've agreed to serve as jurors, to give us your time, to leave your lives, to be sequestered, as it were. That's a remarkable sacrifice. Abraham Lincoln said it best when he said that the highest act of citizenship is jury service. And you're embarked upon that jury service. But it doesn't stop with just coming down and taking notes. It doesn't stop with the inconvenience of being away from your families. When it stops is when you, if you can, render a verdict in this case. And whether or not that verdict reflects the evidence in this case. A verdict rendered devoid of sympathy for or passion against Mr. Simpson or any side of this case. You made these promises, and both sides are mindful of those promises. And we know that you're going to keep those promises. Cicero said that he who violates his oath profanes the divinity of faith itself. And of course, we know that you will live up to your promises. And be fair, and keep an open mind, and decide this case not on speculation, not on conjecture, not on surmise, but based upon the facts. You then, as jurors, are the conscience of this community. Your verdicts set the standards of what we should have and what should happen in this community. You have this rare opportunity, it seems to me, to be participants in this search for justice and for truth. And in the final analysis, hopefully by April of this year, I'm optimistic still, you'll be able to render perhaps the most important decision of your lives. And so we want to keep your minds open and fresh so that you can render that decision impartially to both sides, so that people all across the world can say, this system works. This was a fair trial. These were fair people. So thank you in advance again for your service, for the verdict that you're likely to render, and for all the things that you're doing here for us. Your Honor, the court knows me, and I know Mr. Cochran knows me. I have to interject at this point. This is argumentative.
Were introductory remarks that were similar in nature to prosecution's opening remarks. I think Mr. Cochran has just concluded his opening remarks.
And I trust so, Your Honor.
That's exactly correct, Your Honor.
And again, I hesitate to interrupt another lawyer's opening statement, but I simply wanted to make sure that this type of statement was ceasing. Thank you, Mr. Cochran. Thank you. Thank you, Mr. Eisman. I was just about to compliment the District Attorney's Office on their opening statement yesterday. Maybe I'll take that out now. I was about to say they did a thorough job as far as they went. But they're advocates. And all of us, as you will see today, have an obligation to tell you the whole truth of these facts. So in the course of my statement today, let me share with you some of the things they didn't tell you yesterday, and we'll have to wonder why they didn't do that. The evidence in this case, we believe, will show that O.J. Simpson is an innocent man wrongfully accused. Mr. Darden said yesterday that in Richmond, California, and someplace in Georgia, people were asking questions. Well, I'd like to think that in my hometown of Shreveport, Louisiana, my mother-in-law is in New Orleans, Louisiana, and other places throughout this country, today they're asking, why did Mr. Darden spend all that time on domestic violence? This is a murder case. Why did he do that? And then when he gave you this answer, he was going to answer the question for all of America. It's a little presumptuous, don't you think? Because the answer of O.J. Simpson's guilt or innocence will only be determined by you if you're able to do it. None of us were out there on June 12, 1994. We can only deal with the witnesses as they were. And it seems to me that this case, the prosecution's case, based on what we heard in the evidence, will show this case is about a rush to judgment, an obsession to win at any cost and by any means necessary. The evidence will show that the prosecution in this case has enlisted the services Why? Let me just briefly talk about the witnesses that they didn't talk about yesterday and they didn't tell you about. There's a lady who lives next door and works next door to Mr. Simpson's home on Rockingham. This lady was interviewed as far back, I think, as July. She indicated, essentially, that on this night in question, she came out to walk her dog on several occasions. She knew Mr. Simpson. She knew his voice. She knew the Bronco. She'd seen it parked there many times. She will indicate that when she came out and walked her dog at about 8 o'clock, that Bronco was parked at the curb there. And it was parked at kind of a unique angle so that she noticed it. The rear wheels were a little bit further from the curb. And when you go out there, and I think the court will probably share with you that at some point you're going to get a chance to go out to each of these scenes to see for yourself these areas. When you come out of the Rockingham gate and you make your turn, the evidence will show it's a quick turn, and so you can't land the car up quite like you'd like to. But this lady will testify that she was out with her dog and saw that Bronco parked at that particular angle at about 8 o'clock, 8:30 on June 12, 1994, Sunday evening. She will indicate to you that she heard Mr. Simpson's voice at or about the time he and Mr. Cato Kalin went to McDonald's to get the hamburger. But she could hear, because her quarters are right across the fence there, that after he left, she heard something very strange. She heard a prowler that she described out there in the yard with like hard-soled shoes. And she was concerned about this prowler. That's what her statement was. She relaxed when she heard Mr. Simpson return back, could hear his voice back over in the yard. But she was concerned because the people she works for were out of town at this time. She's concerned about this prowler. We'll talk about that more later. She went about her business, and then she heard Mr. Simpson's voice again about 11 o'clock. She could hear his voice at that time as though he was leaving. We know that's correct because he was leaving to go on a trip to Chicago, a pre-planned trip. And then she didn't hear his voice anymore. But one of the important things that she tells us is that after Mr. Simpson had left, after 11 o'clock, she heard men's voices over on the Simpson property between 12 o'clock up till about 2:30 or 3 o'clock in the morning. Heard these men's voices over there talking. She didn't know what was going on. I hope I told you that when she came out to walk her dog at 10:15 that same night, she looked at the Bronco, and the Bronco was parked exactly the same way, at that curb, same way. When she saw the Bronco the next morning, it was parked that same spot, the same place. And one of the most unique things about this lady is the fact that the morning of June 14th, that Monday morning, a police officer came over to her residence to ask her what she'd heard and to put her on alert that if she found any weapons or if the gardeners found any weapons, to let them know. And she can identify that officer as Detective Mark Furman. Detective Mark Furman will play an integral part in this case for a number of reasons. Now, it's very interesting that the prosecution never once mentioned his name yesterday. It's like they just want to hide him. But they can't hide him. He's very much a part of this case. We can only ask ourselves, why didn't they mention him? I think that answer will become very clear to you as the case progresses. But she will identify Detective Furman as the person who came over and spoke with her. And she told him at that time about her observations, about hearing this prowler, and about the fact that she heard these voices that went on until about 3 o'clock because she couldn't go to sleep until about 4. And when she woke up, it was like 7:30 or 8. And he was there showing his badge through the door. And she saw him on television at the preliminary hearing. So that's how she could identify him. He said that somebody from the LAPD will get back to you. But they never came back. They never came back at all. Because there's a rush to judgment here. There's another witness, Mary Ann Gerches, a very interesting lady, has her own business. On this particular night, in June of 1994, June 12th again, she wanted to find a place in the West Los Angeles, Brentwood area. She drove her car after she closed up her business on Sunday evening and went to Catholic church. Went to Mass, went and parked a car. And she came over there on Monday. Very interesting. Before I tell you what she has to say, let me tell you her contact with law enforcement. The evidence will show that Mary Ann Gerches, after she became aware that what she had seen had some great relevance to this case, started calling the police. She kept being transferred around, couldn't get anybody really to talk to her. Finally, when she finally reached the police officer, they told her, we've got that case all wrapped up. They didn't want to hear from anybody else. And then, lo and behold, she called the district attorney's office. Spoke to a person whose name will be revealed during the testimony. And she didn't feel she's treated quite appropriately. In fact, she will say that the person put her on hold and said, excuse me, I'm talking to a psychic right now, and I'll get back to you. I guess it was part of that hotline they had. So it seems they're more interested in talking to a psychic than talking to her. So ultimately, She called the defense, and we talked to her. Walked with her out of the scene. Here's what she will testify about. That on June 12th, 1994, sometime after 10:30 in the evening, she's walking down Bundy. She's looking, it's a warm night, she says. She's looking for places that have signs up to rent or to lease. That Miss Nicole Brown Simpson's condo, you recall, is on one side of the street, that's the west side, and she's on the east side of the street. And at about 10:45 p.m., she sees 4 men who come within 10 feet of her, 2 of which, gentlemen, appear to be Hispanic. I think the other are Caucasian. Several of which I believe have knit caps on their heads. The 2 who are behind apparently have something in their hands they're carrying. She thinks they may be undercover police. She doesn't know. They get into an unmarked car and they speed away, and she sees them. And that's what this lady was trying to tell the police, trying to tell the district attorney, trying to tell anybody who would listen. But they didn't want to listen because they made their decision in this rush to judgment. There are other witnesses that I won't bother you with right now because we'll talk about them later on in the course of the opening statement that bear upon that evening. But I will share just 2 of you because it sets the stage for many of the remarks that Ms. Clark made yesterday. You'll recall that in her opening statement, quite well done, Ms. Clark kept telling you that she had to fix the time of death in this case at about, what'd she say, about 10:15? She had to make it 10:15, and she made it based upon a dog's wail. Now, this is the first case you'll ever hear where the prosecution's theory is that you've got to determine the cause of the time of death by a dog's wail. And this is most scientific of all cases. But there's a reason why she wants that, because she wants to give enough time for her theory about O.J. Simpson to work. But we will produce for you, and hopefully all these witnesses will be available. As you're well aware, these witnesses are afraid. This could be because of all the media attention, but we're going to try to get them. And what I say to you is what these witnesses have said to us at this point. There's 2 people who have been to Metzaluna restaurant, the same restaurant. Mr. Dan Mandel and Miss Ellen Aronson. They've been on a blind date. It's like their first date. And they're walking home. They walk home and they come right down Bundy also. It's very interesting. As they walk down Bundy, they walk on the west side of the street, right past 875, Miss Nicole Brown Simpson's residence. And they walk past there, and it's interesting because as you saw from those pictures, and we all apologize you have to look at those pictures, and certainly to the family, and we want to be as careful as we can with those pictures. But if you saw those pictures, you could see with the gate open, and you walk right past, the sidewalk comes right down, and the bodies were very visible with the gate open. They didn't see any gate open or any bodies or anything. And it was like 10:25. 10:25 at that point. So what does that do to their theory about 10:15 and the dog's will? Now, who are we going to, well, I won't be argumentative. At any rate, there'll be evidence that at 10:25, that people who walk past, who have no axe to grind, have nothing to do with this case, who they know about, we know about, don't see any crime having been committed. There are other witnesses who are going to testify they don't hear any dog barking at 10:15 or no plaintiff wail, whatever that means. And so, in this initial phase of the opening statement, what I've tried to share with you is that all of us, it seems to me, have an obligation to share with you and be as honest and forthright as we can. In that connection, you'll recall that Ms. Clark yesterday talked on a number of occasions about the limousine driver and what he saw. You recall she said to you that the limousine driver, when he came and left to take Mr. Simpson to the airport, she told you that he did not see the Bronco parked there. It's not exactly what he said in his testimony at the preliminary hearing in the grand jury. And I'd like to read that to you if I might. He says this question: did you make an effort to look and see if there were any cars there? Answer: I looked to the right to see if there were any cars coming down the street. Well, I'm asking you if you looked.
Objection, Your Honor. Objection, Your Honor. This is taken from a different portion of the preliminary hearing.
Overruled.
May I proceed, Your Honor? Thank you. Did you make an effort to look and see if there were any cars there? Answer: I looked to the right to see if there were any cars coming down the street. Well, I'm asking you if you looked, made an effort to see if there was a car parked. Answer: no. There might have been a car there and you didn't see it? Correct. Now that's under oath before the grand jury. Now let's look at the preliminary hearing. What he says there, at the second time this man testified. Then did you leave? Yes. What gate did you leave from? The Rockingham gate. And which way did you go on Rockingham as you exited the gate? I made a left. So you'll have to picture that. As he's coming out of that gate, he's in the driver's compartment, he's going to make a left. The Bronco would be to the right. And which way did you go on the Rockingham as you exited the gate? I made a left. Question: did you look to see whether any cars were parked on the right side as you faced the driveway of Rockingham outside the residence? Answer: I didn't look to see. You weren't looking at the parked cars? Answer: yeah. You were looking to see if there was traffic. Answer: yes, of course. So, I used those examples early on to talk about our contention that there is this rush to judgment in this case. That when Ms. Clark said yesterday that they did everything they could to exclude Mr. Simpson, we're going to talk to you about the trails that they didn't pursue, that didn't go down today. We're going to also talk to you about this evidence, what we call the lack of integrity of much of the prosecution's evidence. You saw yesterday some pictures of this crime scene, and the crime scene was certainly bloody. We all acknowledge that. But I think you'll find the evidence will show that the LAPD, in its infinite wisdom in this case, assigned a trainee named Mazzola, who was the officer in charge of collecting this evidence. This was her third crime scene. And contrary to what you heard yesterday from Ms. Clark, our experts, and we have a number of experts that we call to testify. In fact, one of our experts is named Dr. Kerry Mullis. Let me tell you who Dr. Kerry Mullis is. Dr. Kerry Mullis is a DNA expert. He is the man who invented PCR, polymerase chain reaction. He is the man who received the Nobel Peace Prize for this invention. And he will come in here and tell you about this evidence, how sensitive it is, and how these police departments are not trained in the collection and use of it. That this is, by all accounts, 21st century cyberspace technology that is being used by these police departments with covered wagon technology. And so when Ms. Clark tells you yesterday that it's possible to, it's like cooking or doing something like that, she said she wasn't an expert, and I agree now on that, at least. She's an expert lawyer, but not in this area. The experts will say that's just not true. And so the collection of the evidence becomes very, very, very important in this case. And so, you know, when they were trying to hide Furman yesterday, there were a couple of pictures yesterday of an officer leaning down, pointing at the glove and the cap and everything. And you notice that as they talked about it, that was Officer Furman. Never bothered to mention his name, never bothered that. And so we have then this concept of the prosecution's theories. You heard Mr. Darden stand up and tell you his theory of how this happened. And the theory is only good until the facts come along and makes clear to you what actually took place. And so we think that if you keep an open mind, you'll be able to deal with these theories and then apply the facts, which is your job as the sole exclusive judges of the evidence in this case. Now, Mr. Darden, when he addressed you yesterday, spent a long period of time talking about Mr. O.J. Simpson's marriage to Miss Nicole Brown Simpson. And he spent a lot of time, and he told you a number of things. He told you how, for instance, that this was like a terrible marriage and that all kind of bad things happened, and these people were together 17 years and was just terrible all 17 years. I think you'll find that's not exactly true. He told you how Mr. Simpson was in, how did he describe it? An ugly mood on June 12th, 1994. He told you also that Mr. Simpson came there with some flowers. Well, we'll forgive him for that. Mr. Simpson didn't come with flowers. He was there. The testimony will be he was there, he left and went and got the flowers and then came back. But let me try to show you graphically Mr. Simpson with his daughter. And Your Honor, I'm now referring to a photograph, and I need to check with my colleagues, and I believe this will be Defendants 1, if the court would allow, or A, whichever court would.
Defense 1.
Defense 1. Thank you, Your Honor. This is a photograph of Mr. O.J. Simpson and his sweet little daughter, Sydney Brooke Simpson, shortly after this concert at Paul Revere High School. This picture was taken, and I think you'll even see the date. You see 6/12/94. This picture was taken by a Dr. Ron Fishman, who was at that particular recital. They were all friends. He will tell you that since Mr. Darden wasn't there, he's got his facts all wrong. O.J. Simpson, according to the testimony, was not in any ugly mood. He talked to Ron Fishman. He was there to see his child. And you'll hear that he came back to Southern California from New York City, where he was on business. He was out of town almost all that week, specifically to try and come to this recital. He had to leave right after this to go to Chicago. He was already back east in New York, and we'll produce a friend who told him, why don't you just stay back here? And Mr. Simpson told him, I missed my daughter's first communion because I was out of town on business, so I want to go to this dance recital. And that's what he did. Does that look like he's in an ugly mood to you there? And you'll see the two of them there at that point. Wherever we can, we're going to bring to you the facts versus their speculations and theories about this man. They don't know this man. The evidence, you will know him by the conclusion of this case. And so, Mr. Darden kind of apologizes at the end and says, this isn't character assassination. You know, when somebody says that, who said it was character assassination? Because he knew that's exactly what it was. So at the very end, when he said it wasn't character assassination, that's exactly what he had done for an hour to O.J. Simpson. He's not charged with any domestic violence. This is a murder case. And in their pursuit to win, they're trying to dredge up some theory to give you a motive, because they don't have a motive for this and these particular crimes. And who's to say that those 4 men we saw running from the area of 875 hadn't followed Mr. Ron Goldman there, as opposed to looking for Mr. Nicole Brown Simpson? Can they?
Counsel. Your Honor, I interject once again on the grounds previously stated. This is argumentative. This is not a recitation of evidence. We've gone beyond the normal scope of opening statement.
All right, the objection's overruled at this time. Thank you, Mr. Carter.
Thank you, Your Honor.
Got a little sidetracked there. Let me see. I think I was indicating to you, who's to say, based upon the facts in this case and the evidence, that those 4 men that Marianne Gertjes will testify about hadn't followed Mr. Ron Goldman to that location. Another thing that happened yesterday that is not true that they told you. Ms. Clark told you that Mr. Ron Goldman checked out of work. He was going to come over and do a favor for Ms. Nicole Brown Simpson to bring the glasses, and she described for you how he was dressed. I think she said with some white shirt and black pants or whatever, that he then came over to the residence. You saw those pictures, as terrible as they were. He was in some jeans and some kind of shoes that are far different. And the evidence will be he went home dropped off a book, changed clothes before he came to Nicole Brown Simpson. But the reason that you weren't told those facts is because it's important they keep this 10-15 time. They've got to keep everything squashed in there so they can tell you, oh, he had plenty of time to commit this crime. And when we conclude today, you're going to see there was no time to commit this crime. And so, to wrap up this part about the so-called character assassination or whatever, what I'd like you to do, as with all of the evidence in this case, is to keep an open mind till you've heard both sides. They may try to bring out incidents about this marriage, and these people did divorce in 1992. And unfortunately in our society, there are far too many divorces. People don't always get along. And we sometimes get divorced. Some of you probably got divorced. And it's unfortunate when that happens. But I'd like you to keep an open mind. But I think perhaps the most important thing about this whole area is this as a response to Mr. Darden. There is an expert in the United States whose name is Dr. Lenore Walker. She's, by all accounts, the #1 expert in America on the field of domestic violence. She's been called by some the mother of the battered woman syndrome. Now, they didn't talk about this yesterday, but Lenore Walker will be a witness for the defense. And I want to talk to you about her and her testimony because I think it'll be relevant as we talk about Mr. Darden and what he has to say on this area. We know that Mr. Darden is not an expert in this area, and he's a lawyer conveying the facts as he understood them. But he wasn't there. Dr. Lenore Walker, this #1 expert in America, perhaps in the world, in this concept, has seen and interviewed and tested Mr. Simpson. She hasn't concluded all the testing yet, but she will testify to you about the results of those tests when she's completed. But she has and does have some feelings about this case and about Mr. Darden's remarks. In fact, as an expert, she's permitted to watch Mr. Darden, and she watched him yesterday. And she was kind enough to share with me last night what her thoughts were about this theory.
Maybe approach.
I'm going to tell what the evidence is going to be.
All right, Mr.
He's going to offer to the jury Ms. Walker's feelings about my specific comments yesterday. My opening statement was not evidence, Your Honor. Ms. Walker ought to confine her opinions to the evidence in the case. And this is argumentative, and it's been argumentative.
Objections overruled.
Thank you. Dr. Walker, along with a number of us in the courtroom when Mr. Darden was speaking yesterday, felt that it's offensive to women to say that they never had a job.
This is argument.
All right, very well. You're right, Your Honor. And let me rephrase
She
that.
was going to testify as to her analysis of Mr. Simpson or what her testimony is going to be. That's one thing. Commentary upon Mr. Darden is something else.
You're right. You're
Thank
absolutely
you.
right about that. Let me see if I can restate that in a positive way, Your Honor. With regard to Mr. Darden's statements yesterday, you recall when Mr. Darden said that Nicole Brown Simpson never held a job, and he wanted to paint this picture for her for being, totally under control and being controlled by O.J. Simpson and under his thumb and that sort of thing. Well, I think that some of us would feel that somebody who raises 2 children, who's an excellent mother, that's a pretty major job, being a homemaker. And we'll talk about whether or not Nicole Simpson was a Barbie doll that one could just make in their own mode. Because even in Darden's statement, he said this was a strong, tough lady. I think you'll find that's what the evidence is going to be. But with regard to this whole aspect of battering, in this case, let me say up front that Mr. Simpson is not proud at all of the fact that he and his wife got into an altercation and she was struck on January 1st, 1989. He's not proud of that. In fact, in the course of this evidence, you're going to see perhaps 3 letters that he wrote apologizing to his wife. But what Mr. Darden and what the evidence hasn't shown you so far was that from 1989, January 1st, 1989, they made a big thing out of that. From that day forward to the present date, there's no evidence that O.J. Simpson ever struck his wife again. Now, you should never strike your wife. But even when he made a mistake on January 1st, 89, he paid his debt for that. He went to court and he pled nolo contendere. He pled no contest for that. He was sentenced to community service and he paid his debt. Now they want to retry that, I suppose. They don't tell you that. There was not any touching after that. In fact, O.J. Simpson did something else. After that incident, he was so contrite that he had a prenuptial agreement with Nicole Brown Simpson. So if they got a divorce, what her share would be. And he went and he had his lawyer put in writing, which was later signed by her, that if I ever strike you again, the prenuptial agreement is voidable. And until the date of her death, that agreement was never made void or voidable. Now those are the facts. And so when Dr. Walker comes and testifies to you, she will talk about the fact that life-threatening violence usually precedes a homicide incident. And she does not find that in this case. She will, I believe, testify that according to the National Institute of Justice, approximately 2.5 million women are battered in this country every year. An intolerable situation. Statistics indicate, however, that between 1,200 and 4,000 of those women are killed. That's 1,200 to 4,000 of the 2.5 million battered. Dr. Walker will testify that it is impossible to use these statistics to prove that anybody who allegedly batters becomes a murderer. You might liken it to an example of smoking. Somebody may get lung cancer. The fact they get lung cancer may mean they smoke and may not. But if you smoke, I can't automatically predict you're going to get lung cancer. And so that this is not a predictable science, according to the lady who's the mother of this particular area. That although domestic violence is a very, very serious problem in this country, the level of violence in this case, the pattern, is atypical. Atypical means untypical of those relationships where a lethal incident often occurs. For instance, stalkers don't go all across the United States working, doing commercials, shooting movies, having a new girlfriend, going out with their life, doing all the things you're going to find this evidence is about. They don't have a new girlfriend by the name of Paula Barberi, who you've been very serious about from April of 1992 to April of 1993 until Nicole Brown Simpson asked to reconcile and get back together. She did it in this way. She sent to Mr. Simpson, among other things, a video of their marriage, a video of the birth of their children, accompanied by a long letter spelling out how much she wanted to get back with this family. I think you'll find that's not stalking. And Mr. Simpson's response was, we've had problems in the past. I have a girlfriend now. I'm happy. Let's take our time about this. But she pursued. She followed up on that. She pursued. She wanted to move back to Rockingham. She didn't like the housekeeper there. She wanted him to fire her. Michelle is her name. And ultimately, she got into an altercation and struck Michelle. He didn't want to fire Michelle. Ultimately, Michelle did leave after being struck. It was her who pursued this in May of 1993 to May of 1994. When Darden talked to you yesterday, he didn't mention that. And we will conclusively prove that to you so that when Dr. Walker talks to you about stalkers demonstrate obsessive behavior that concentrates on controlling the woman at all times and is inconsistent with making a new life,
beginning a new relationship with a woman such as Paula Barberi, traveling away from home on business assignments, all of those things go against any idea of stalking that they would have you believe in this case. Dr. Walker will also tell you that there is a major difference between a wealthy person who gives gifts, someone who uses material possessions to gain power and control. And so the prosecution would have you believe that if Mr. Simpson gives Nicole Brown Simpson a gift, it's going to be bought and paid for. Nothing could be further from the truth. Let me give you an example of the testimony that will come out in this case. Before Mr. Simpson ever got married to his wife, he bought her a condominium in San Francisco and paid $500,000 for it and gave it to her free and clear in her name so she could have money up to $3,000 a month. He never, ever saw any of that money, wanted any of that money. There were no strings attached. This is before they got married. And later on in this discussion, I'm going to talk to you about what I call his circle of benevolence. Those who have come within the ambit and sphere of O.J. Simpson and his philanthropic largesse, what he's done for him. And there are many other things. This $500,000 condo, free and clear, he then gave her some more money to buy the condo on Bundy. These are all her own separate things while they're still separated. He asked for no control. She had her own bank accounts. He gave her $4,000 a month for food at the house. And he paid all of the bills when they were together. Let me talk about this circle of benevolence while we're on it right now. It extended not just to Miss Nicole Brown Simpson, but to her family, to Mr. Lou Brown. He helped him become a Hertz licensee at the Ritz-Carlton in Laguna Beach for 7 years. The sisters, Dominique. He paid the tuition for Dominique for a couple of years at USC till she dropped out. Paid the tuition for Tanya, the other sister, I think, to San Diego State for a year or so till she dropped out. There's a cousin, Rolf Bauer, who worked for 7 years, Mr. O.J. Simpson's chicken franchise, Pioneer Chicken Franchises. The mother, Juditha, was a travel agent. He gave her his business and encouraged his friends to do likewise. This man had a great relationship with his in-laws. He did wonderful things for them. Took them all on trips, paid their way, took them all out to dinner. They'd go to Hawaii and Cabo San Lucas. This is the same man that Mr. Darden was talking to you about. Mr. Darden says that she never worked. O.J. Simpson encouraged her to become a decorator. She became a decorator. He helped her get jobs from his friends. She redecorated the Rockingham house to the tune of $500,000. And he paid her. He paid his own wife a fee to decorate the house. This man that Darden was talking about, this man gives $5,000 every year to the Angel City Links, an inner city black organization. And the condition of his gift every year is it has to be anonymous, that he doesn't want them to know he does that. The thing that he's perhaps proudest about are these next two things I'm going to tell you about. Number one is his mother, Eunice Simpson there. As soon as he was able, he bought her a house. She still lives in that house in San Francisco. This is a man, 47 years old, who grew up in the poor areas of San Francisco, in Potrero Hill, but he never forgot. Became rich and famous, but he didn't forget. So that to this day, he buys the uniforms for the kids at the Potrero Hill gymnasium where the kids go to work out. He still does that, even right now, even while in his jail cell. Bought his mother's house. You'll hear about those kinds of things. And the second thing he's most proud about is that he had a child who drowned at a young age. That's always a tragedy, and you'll hear evidence about that. And the pronounced effect that it had upon him. And after that, he became involved in all of these kind of pediatric endeavors. And he has participated in raising hundreds of thousands of dollars for Camp Good Time, for kids who have cancer. He's very proud about that. There's testimony and evidence about that. People who know him, not people who speculate about him, will come in and testify about those things. And so, when Dr. Walker tells you that for a wealthy person to give gifts doesn't mean you're exercising any control, one of the sisters needed some money, up to $5,000, and he gave it to the sister and her boyfriend. And the condition was, don't tell Nicole. It's a lot of control, isn't it? So when you hear about theories, I'm going to tell you about the facts. So you'll hear from Dr. Walker, and you'll hear ultimately about the battery of tests. And I think you'll find that she will say that in looking at O.J. Simpson and interviewing him and looking at him at this point, she finds no evidence of antisocial personality disorder. I think you'll find that becomes very important in this case. And understand that this is no Janie come lately. This is the leading lady in America who testifies in these kind of cases where a battered woman shoots and kills her husband. So this is an area where, obviously, you get a chance to see her qualifications and her ability as she goes about this. Now, back to Mr. Darden's discussion. It tells you a number of things that I'd like to address, at least some of them, with you now. We've already covered the so-called ugly mood by showing you the photograph. We've covered the aspect of the flowers, because Mr. Simpson did get flowers, but he went out and got those flowers. We'll cover the aspect, let me talk to you about Mr. Simpson at that particular recital. I've told you how he came back to California specifically to go to that recital. That he'd come in to Paul Revere at about 5 o'clock and saw his ex-wife. He had to get his ticket and take his ticket back to the person at the door. That his daughter was 30 or something on the program. You've been to those programs where your child is going to come up and she's like, there's probably 100 people there and your child is like 99th and you have to be very interested until you get there. So this was like 30-something and she was at the very end. But as all parents, you kind of sit there and you're really proud of the youngsters and you do that. As the program was going, he remembered that he didn't have any flowers. So when he first got there and he was 2 seats away from his ex-wife, Miss Nicole Brown Simpson. Wasn't staring at anybody. Wasn't glaring at anybody. Wasn't jealous about anything. In fact, you'll hear the conversation he had with Ron Goldman, who was still in the group. There was a group of them who ran around together in Brentwood. And O.J. Simpson was commiserating with Ron Goldman about his problems he was having. Please forgive me. Ron Fishman, excuse me. I heard those sounds. I'm sorry about that. Thank you. Ron Fishman. He's the man who took this picture here. He was talking about his problems with Cora Fishman and the group that ran around together. The testimony will be that he was saying, I'm glad to be out of it. I'm back with Paula. And was he back with Paula? Yes, he's back with Paula. The night before this trial is over, we'll have another picture, but this picture will do for now. By the way, this is Mr. Douglas is going to help us because there are some graphics and things. Hope you'll bear with us. Thank you, Mr. Douglas. Your Honor, you please see this picture. Would you like to see it? We'll call this, this is...
I thought we had agreed that it would be defense 1, 2, 3, 4.
I think the clerk has not changed it.
Right. But we're going to have so many, Mrs. Robertson. I thought we agreed on this. For now, we'll call it defense 2. And Mrs. Robertson will explain to me the error of my ways at lunchtime. No, I'm not.
Oh, I see. This is in 201. And number 201 is another example of O.J. Simpson. This photograph, there'll be testimony, was taken on June 11th, on Saturday, June 11th. That is a charitable fundraiser. I think $25,000 a plate, by the way, to the benefit of Israel. And that's O.J. Simpson there. Now, that night, on Saturday, June 11th, he went with his girlfriend, Paula Barberi, who had picked him up at the airport on Friday evening June 10th, when he came back from working in the East from New York. They spent that time together, and they went out Saturday evening. And so this picture, again, is graphic evidence of O.J. Simpson and who he really is, it seems, to us. As I said, there is another picture of Paula Barberi with him there that we don't have yet, but that we will. Now, Mr. Darden talked a lot about Miss Simpson being weak and that he exercised all this control over and picked her friends. The evidence will show that Miss Nicole Brown Simpson was a very strong, independent woman, very attractive, and an excellent and wonderful mother. But the one thing they never fought over and never had any arguments about were those children. But they both mutually loved those beautiful children, and that was very, very important, it seems, to both of them. That she picked and chose her own friends. That O.J. Simpson or no one else could tell her who her friends were to be. She had whatever friends she wanted. She did whatever she wanted. He tells you about 2 incidents where he alleges there's stalking. Let me tell you the facts and the true facts about those incidents, backed up with witnesses. There's a man in Los Angeles named Joe Stellini who owns a restaurant in the West Side out on Pico. He's a good friend of O.J. Simpson's. They went out to dinner one night. And while out to dinner, they became aware of Miss Nicole Brown Simpson and their party. This was the time when they were separated. And they had an agreement, generally, that if one or the other came in while they were there, the person who was there first would leave or whatever. There wouldn't be any problems. The incident regarding Joe Stellini had nothing to do with Miss Nicole Brown Simpson or her party. He was out to dinner. They might frequent the same kinds of places. You'll hear from Joe Stellini, and you'll see there was not anything about any stalking. The other incident was about Metzaluna, I believe. It was an incident where they both were at this restaurant. Mr. Simpson's party had already been seated when he came in. And again, you'll hear from these parties who will tell you that these were not any stalking incidents. That if you live in Brentwood and there are restaurants, hot restaurants in that area, and you go out to dinner a lot, you're going to run into each other. And there was no hostility, no stalking, no jealousy, no nothing. And so he tries to paint O.J. Simpson as a jealous man. Let me tell you what the evidence is going to be about that. You heard about this incident of Keith Zlomowitz. I'm sure as a witness who's going to be called. Mr. Garden described it. Remember he said yesterday, well, he didn't punch out Nicole and he didn't punch out Keith, or words to that effect. He certainly didn't. What happened was Mr. Simpson, in one of these incidents, had seen his ex-wife out. They went out dancing afterwards. And he stopped by our house afterwards to try to talk to her. He would go by and woo her on occasion. And the evidence will be that when they first broke up, he was advised in January of 1992 that she wanted a divorce. Between January and April of 1992, it was hard on him. Been with somebody for 17 years, he didn't want to lose her. He likes family. He learned that from his mother, and he's got this close-knit family. And he likes that. He loved his children. He didn't want to lose his wife. But something happened in April of 1992. As soon as he became aware that she had a boyfriend, from that point on, his interest changed, and he went on. And when he saw what he saw with Keith and Mrs. Simpson, he then went on with his life with Paula. That's when it started, in April of 1992. And so what happened was he wasn't peering in any windows. He came to the front door to try to see his wife. And he looked in, and he saw his wife making love to a gentleman on that couch. Now, according to Chris Darden, wouldn't you expect that he would just blow up, become ballistic? He went home, the evidence will be. He came back the next day to talk to Mrs. Simpson about the fact that the kids were upstairs, and what he saw them doing, he didn't think would be appropriate. One of the kids came downstairs. And so when he came back on the next day of this incident, he saw Keith, I think, sitting astride Miss Nicole Brown Simpson giving her a massage or something in her shoulders. O.J. Simpson talked to both of them, shook Keith's hand, went on his way, and said essentially, look, I don't think you should be doing this in front of the kids or whatever. They didn't tell you that Keith Zlomowicz moved in with Nicole that summer. But O.J. Simpson was back with Paula. Didn't bother him. He knew she was there, that Keith was there. Was he stalking? Was he jealous? Was that a rage? I think not. So, again, I want you to take these facts and look at them. But there's an even more painful incident, probably, that tells you that he's not jealous. He has a very close friend, somebody who's very near and dear to him. The evidence will show who had a relationship with Nicole Brown Simpson, because she told him so when they got back together, and this gentleman told him so. And it was hurtful. But he never said a harsh word to her or this gentleman. He didn't go ballistic. He didn't do any of those things. In fact, you know what he did? He let this gentleman get married at his Rockingham house after learning this gentleman had been intimate with his wife. That's what O.J. Simpson did on that occasion. Your Honor, may I put your name?
Gentlemen, we're going to take a 10-minute recess. Love the tie. Love the suspenders. All right. Let's take a 10-minute recess, ladies and gentlemen, if you'll just step back into the jury room, and we'll resume in 10 minutes. Apparently, the Public Information Office has received several comments that apparently jurors are visible in the reflection off of the bailiff cubicle there. I have looked at the videotape. It does not appear apparent to me, but I only took about 30 seconds to look at it. We'll look into it at noon, but I just thought I'd let you, don't go away.
Well, I guess I can put a cloth there, but there's security concerns there, right?
No, what I'm going to do is I'm going to take hairspray so that it won't reflect, is what I'm going to do. But rather than have everybody move while I hairspray it, we'll... All right, Deputy Magnero, let's have the jurors, please. And Mr. Cochran, I'll allow you to, if you want to slop over a couple of minutes there, but close to 12, you know, conclude your thought. And my guess is we're, if I had to guess, that was the introduction.
I'm sorry, it'll be this afternoon. You're worried about witnesses? We're leaving at 3:30 today, you judge? Yeah. I'll make sure I finish before then. I will, if that's all right. I'll, you know.
All right, here are the jurors. All right, record should reflect we've been rejoined by all of our jurors. Counsel, ladies and gentlemen, be seated, please. Thank you. All right, Mr. Cochran, do you wish to continue?
Yes, I do, Your Honor. Just 1 second. I'm trying to pick up the last thought.
Certainly.
Thank you very much, Your Honor. Thank you very much.
I wanted to try to pick up where we left off. To conclude those remarks about this friend, I think that speaks volumes about Mr. Simpson, his stability, his relationship with his ex-wife. I think the evidence will also show that in about May of 1992, Ms. Nicole Brown Simpson came over to the Rockingham house and said she'd found a boyfriend, somebody different than Keith, where the incident was April of 1992, and asked Mr. Simpson for some advice. He, of course, knew at that point that it was over and he was back with Paula and went on with his life, as I said, until such time as in 1993. She decided she wanted to get back together at that point. Now, to clear up, I want to always keep the faith with you about being as accurate as I can. The two incidents that they talked about, on the one incident involving the man Joe Stellini, that was at Mezzaluna. The other incident was a restaurant called Tryst. In both incidents, there was no problem, no fight. In fact, in the Tryst incident, I believe it was, at the Mezzaluna incident, Mr. Simpson went home with his wife that night. So that there was not any incident where they were stalking or fighting, anything like that. There was no obsessive behavior. I hope that we'll put those in some kind of perspective. Mr. Darden talked in his opening statement about a 1985 incident in which some damage was done to a vehicle. And as I understand it, the testimony will be that was not any incident in 1985 because Miss Nicole Brown Simpson was pregnant, had a C-section later in that year, and they didn't have any situation like that. They did have some discussion apparently maybe in 86 or in 84. There was some damage done to her car, and she was not in that car. She was not struck on that occasion. So I think you'll find an incident of not great consequence. And Mr. Darden talked about the 1993 911 tape that you've heard so much about. And I think even he conceded yesterday that in that situation, although you could hear Mr. Simpson's voice, and he was angry, Mr. Simpson never laid a hand on his wife, never called her a name. And I think the important thing about a trial is that finally you're going to get to hear all of this tape. And what you're going to hear, Mr. Darden didn't tell you this yesterday, is that there was a discussion on this 911 tape. And he alluded to the fact that Mr. Simpson couldn't get out of his mind what he'd seen back on April 1992. Well, now, first of all, most of us might have a problem getting that picture out of our mind of seeing your wife making love to someone else. But at any rate, this wasn't the reason for the argument. What had happened was, and the facts will be, that when they started trying to get back together again in 93, they had an agreement that they would take the pictures of their boyfriends and girlfriends out of the, you put them away, basically, which seemed to be a reasonable request. And there was a dispute because when Miss Brown Simpson would ever see Paula Barberi's picture, she was very upset about that. And Mr. Simpson, on this date, I believe, saw a picture of somebody that she had dated during the time they'd been separated. And he said, gee, what's fair for me would be fair for you. And they got into this conversation that went over a period of time. At some point, there was just a verbal conversation that escalated and tempers flare. It sometimes happens with married couples. Doesn't make it right, but sometimes it happens. He came over to her house, and he did, in fact, kick a French door. The evidence will be the door was already broken. He fixed it, but he never at any time struck his wife during this period of time. And what he was saying, at some point, she says, OJ, be quiet, what about the kids? And he says, essentially, you weren't thinking about the kids and being quiet when you were on the couch with Keith. And I think you'll hear that on the tape. So you put it in perspective, and the important point to make is that nobody was ever injured during this period of time. In fact, there is a tape recording and a transcript from some police officers who came out and talked with these parties. And in that tape, you'll get a chance to hear what Ms. Brown Simpson thought about that incident. And they also talked to O.J., who waited there for him. He agreed to fix that door. And they went on with their lives. They went on and continued during that period of time to get along. This was the time they were back together. You should note that Mr. Simpson, because of how he's conducted his life and the things he's done in his life, has been able to amass some assets. Not bad for a young man, a spindly leg youth from San Francisco, who suffered with rickets, who had trouble walking, was cared for by his mother, who grew up to become the greatest running back in the history of the National Football League. And so, because of that and his commercial endorsements and things, he's able to have several homes. He has a home in New York. And the evidence will be that in August of each year, because of his commitments with NBC, he would go and live in New York. And so he wouldn't try to control Miss Nicole Brown Simpson. I mean, she would do what she wanted to while he was here. Even during '93, he was living in New York from like August to like January, maybe after the Super Bowl or whatever, till August to January. He'd be back there at his New York house. He also had a house in Laguna Beach in Orange County. And one thing I forgot to tell you about the circle of benevolence. He assisted his wife in buying a condo in Laguna for herself, separate from his house. So when she was at Rockingham, she had 2 condos in her own name. One in Laguna, one in San Francisco, she's getting money from, and living at Rockingham. They didn't tell you about that. He also had bought some property in Cabo San Lucas where he planned to build. All of the things that he was doing was about the family, like keeping the family together, like doing things with in-laws and with friends and with the children. So I think you'll hear evidence about the fact that he was away at great periods of time. And while I'm about that, let me tell you about the kind of schedule this man had. You won't be able to see his calendar yet, but at some point, hopefully, we will. If you went back and looked at Mr. O.J. Simpson's daily calendar from January to June of 1994, you'd find a man that in January was out of town and probably still living in New York almost every day. But he was out of New York because he was traveling. Some of you who know this is Super Bowl week, you can imagine that he was in Atlanta that week, because that's what the Super Bowl was last year. That the evidence will be that this was a time that he and his wife were trying to make it, that he took some family members, the Browns from Germany, to the Super Bowl in Atlanta, paid for all of them, got them 50-yard seats, took them to all the big parties that are going on this week. He was again out of town during almost all of that particular month. If you looked at his calendar and you were able to be testimony that in February, he spent a lot of time in Cabo San Lucas. He was in Nashville, in St. Louis, in Miami again, involved in charitable work. Few days where you find he was even here in Los Angeles. If you looked at March, you'd find that he was in New York. He was doing Bryant Gumbel's charitable golf tournament in Orlando, Florida. Back in New York again. He was all over the country doing various and sundry things. You got to the month of April, he was back in Cabo. From there he came back to Los Angeles. Then he went to Puerto Rico. Evidence will be that some of you know he's an actor, a would-be actor, and that he made this movie Frogman during that period of time in Puerto Rico. Again, very much out of California. And in May, with the exception of some things that he came to do for his children, and by the way, again, talking about the kind of things that he would do at Rockingham. And you'll see this place at Rockingham. On May 22nd, he had a school picnic at Rockingham. We had a number of kids, and I think that's for the Sunshine Preschool. That is where his son Justin went. It was a fundraiser for this school. They have all these kids, and all the people would come to his house at Rockingham to raise money for the school. On May 22nd, he did that. And Nicole Brown Simpson was there. And even though they had agreed in May, earlier that month in May, and he was now back with Paula, when Nicole Brown Simpson got sick the week of May 15, 1994. She had pneumonia. O.J. Simpson was the one who took her soup, who tried to nurse her back, to get her back on her feet, even though they agreed they weren't going to be together anymore. You heard testimony with regard to that. And he continued, of course, being in and out of town. In June of 1994, he'd had and had taken his two children, Sydney and Justin. And let me say something at this point. Mr. Simpson has two other children that he's equally proud of. The minors cannot be here, obviously, for obvious reasons. But he has two other children that he's equally proud of, and they're here in court today. And there's Arnell Simpson over there and Jason Simpson, sitting between his two sisters, Carmelita Duro and Miss Shirley Baker, and the balance of the family. And you've met Miss Eunice Simpson already. So he, on May 5th, attended a pediatric AIDS affair. Again, his interest in children and AIDS and charitable work, along with Paula. And he took the two younger children. It was a real fine day. And that was on that Sunday. On that Tuesday, he left to go to Washington, D.C. Again, he left town. He had to work. On Wednesday, he was working for Hertz in Washington, D.C. On Thursday, he's in Connecticut, working again at one of his board meetings. He's on these various boards, some charitable, some profitable, hopefully. He was in Connecticut. On Friday and Thursday night, he was in New York with his friend Bender. And he'd work, and he'd try to play golf during these periods of time. You recall I mentioned that Mr. Bender had suggested, you're going to be in Chicago on Tuesday or Monday night. Stay over. He came home for the recital. And when you see his calendar, you'll see it's planned all the way out, far beyond June, of course, of 1994. But it gives you a sense of this man, this man's life, what he'd been able to do with his life and with himself. I point out these things to you because I think as you look at all of the incidents that Mr. Darden talked about, it puts them in perspective. This is not a case about domestic abuse. It's a murder case. It's a murder case about who did these horrible crimes. That's going to be your decision. Not to think that O.J. Simpson is a bad guy or a good guy, for that matter, but to get a picture of him. I think that you'll agree with me that after you hear the facts, you'll have a clearer picture. Now, about we talked about the 1993 incident, I think we did. And I think those are the main incidents that Mr. Darden talked about. One thing I wanted to point out to you is that there will be, I believe, testimony that as these parties got a divorce, as so often happens, Ms. Nicole Brown Simpson had her deposition taken. And she made a statement in that deposition with regard to whether or not he'd ever physically struck her after the '89 incident. And it'll be interesting to hear what that is. That this Mark Furman becomes even more relevant in this case as we go along and discuss it, because he was the officer who had supposedly responded, he says, in '85. There's other evidence that the incident involving the bat and the Mercedes was not in '85 because she was pregnant. But he writes a report 4 years later, in '89, saying he had an indelible impression of Mr. O.J. Simpson and coming to that location. An indelible impression. So we'll have to pursue what that means in this report that he wrote about that incident some 4 years later and whether or not it was accurate. It was not done contemporaneously with the incident. Mr. Darden also said to us that this was not a tabloid prosecution. Well, that's interesting, isn't it? He used those words, didn't he? He said, first of all, this wasn't character assassination, which we now know it was. And he says it's not a tabloid prosecution. Well, I think the evidence will be that after this book that you've heard about from his so-called friend Faye Resnick came out, it's when the people started getting all these witnesses who wanted to come forward, talk about these incidents. So whether or not it's a tabloid prosecution is not for me to say. It's going to be for you to say. Let me say this about Faye Resnick.
Counsel.
I'm
sorry to interrupt this.
Okay. Go ahead,
Your
sir.
Honor, once again, my objection has been previously noted.
I caution you, Mr. Cochran, about what you're just about to launch into, because that person's not on the witness list. And when you say, "Let me tell you about somebody," I'm concerned.
You're right. And there's a possibility that...
All right, I
Well-
think we should hear these objections at the sidebar.
Okay.
However,
And
Mr.
I tell you, let's do it without the recording. I think we can resolve it. Okay?
Please.
I'd like to have the reporter present.
No. All right, thank you, counsel.
Oh, excuse me, sir. Thank you. Thank you, ladies and gentlemen. Excuse me. I talked just briefly about this witness, Faye Resnick, and you may or may not hear from her. She's on our witness list. There's a possibility. We may call her for a number of reasons because...
Object, Your Honor. There's only a possibility.
Counsel, overruled.
The reason why I think the evidence will show and will be relevant to you is that on or about June 3rd of 1994, Faye Resnick, who had had a long-time relationship with a Dr. Christian Reichart, whom we will definitely be calling, they'd been living together for a long time. And because of her drug usage, because of the fact she was freebasing cocaine, he put her out literally. They broke up. She was one of these parties who they ran in this circle out there in Brentwood. And when she was put out on June 3rd, which I think was a Friday, she then moved over and lived with Nicole Brown Simpson because they were friends. They would go out at night. These were all friends. The evidence will be these ladies would go out 2, 3, 4 nights a week and stay out till 5 o'clock in the morning. Nobody was controlling these women. There's a group of them, and you'll hear about it. They go out dancing, they do whatever they would do, and we know Faye Resnick was using drugs during this period of time. It got so bad, the evidence will be that on June 8th, 1994, they had what we call an intervention, that Nicole and Kristen Reichart and her former husband, Paul Resnick, all got together to try and convince her that she had to go into a drug treatment facility called Exodus. And on the 8th of June...
Excuse me, counsel, I'm sorry once again. Your Honor, you had asked us or given us leave to address these issues.
Overruled. Please be
In a
seated.
noon hour.
Please be seated.
Very well.
Thank you.
goes into a drug treatment facility on June 8th, and she remains there, and she's there on June 12th. And I think you hear from the evidence that she is one of the people who calls Miss Nicole Brown Simpson on the night of June 12th, perhaps after 9 o'clock, that particular night, from this drug treatment facility. We'll be talking about that and her role in this whole drama. To conclude, then, what I've tried to do in this opening statement is to lay out for you the fact that in almost everything you hear in this case, there are two sides. That as jurors, I'm sure you're not going to rush to judgment. But this should not be a case about character assassination, and I hope you will keep an open mind until you hear all of the evidence as it relates to who Mr. Simpson is. Now, shifting our attention now to the discussion, the very able discussion of Ms. Marsha Clark yesterday. It seemed to me, as you summarized what she had to say to you, that her argument broke down, or, well, it was argument at the end, but her opening statement broke down into a discussion of timeline and so-called evidence trails. Let me first of all talk to you about the concept of the timeline. We've talked a little bit about that. And let me tell you what she didn't tell you about. Some of this we'll cover, so I won't be redundant. But there are witnesses like the lady who lived next door to Mr. Simpson. There's a Mr. Tom Lang that she knows about and didn't tell you about, who on this particular night, June 12, 1994, was walking his dog on a street called Dorothy Street, right down the way from Mr. Nicole Brown Simpson's condo at 875. That from his vantage point, just a short distance on the corner, he looked up and he saw a lady that he believes was Miss Nicole Brown Simpson, either embracing someone at a vehicle at the curb, and behind Miss Simpson, he saw a man that he described as a Hispanic or Caucasian, standing with his hands clenched, standing there looking as though he was angry. And he didn't know why this man was looking like this. And this is about 10 o'clock on June 12th. Whether he was angry because Mr. Lang didn't know whether he was angry because his dog was loose or what. But again, this is what I expect his testimony to be. This is at 10 o'clock, and he sees a lady that he believes is Nicole Brown Simpson at that point. I talked to you briefly before about Ellen Aronson and Dan Mandel, who she didn't talk to, but she's talked to them, but she didn't talk about them yesterday, as they walk past this place, right at about 10:25 or thereabouts. And there's another witness, whose name is Robert Heidstra. Robert Heidstra is in an alley one street over. But when you go out there, you'll be able to see how well you can hear late at night, especially on a Sunday night at this location. Mr. Heidstra, according to his statements, is walking in this alley. And now it's about 10:35 or 10:40. As he walks parallel to where the Bundy residence is, will be then looking west, he hears sound of like arguing, and he hears someone or a voice say, "Hey, hey, hey," and he hears the sound of a fence closing, and he continues on walking his dog. Now this is at 10:40 or thereabouts, and you know then at 10:45, Mary Ann Gertrude sees these four men running from 875 down toward her direction, and she believes they're coming after her at that point. In her statement to you yesterday, Ms. Clark talked to you a lot about Allen Park, and I read you some of his transcripts, some of his testimony that you didn't hear about. And I think there'll be considerably more with regard to Mr. Park and to Mr. Cato Kalin. An interesting man, and I think that it'll be interesting when you hear from Mr. Cato Kalin about Mr. Simpson and how he appeared that night. Just before we wrap up for lunch, I think the evidence will show you that in order to believe that O.J. Simpson committed these horrible murders, you'd have to believe that he came back from back east where he'd been working to come to his daughter's recital, attended that recital. You see his picture there. He was home getting ready for a trip to Chicago that had been long pre-planned, that he was hungry. And the evidence will be that he didn't have any dollar bills or $20 bills, that he asked to borrow some money from Cato Kalin. Cato Kalin gave him this money. He went and had a Big Mac. You'd have to believe that he was planning to kill his wife either before he got this Big Mac or then went and got the Big Mac, that Cato Kalin will describe. He was dressed in some kind of a sweat clothes and some tennis shoes. If you follow the people's case, you'd have to believe that he then came home and said, "Gee, I think what I'll do is I'll go over and kill my wife now, and I think I'll take these tennis shoes off and put on some dress shoes, some hard-soled shoes, and change clothes," knowing he's going to be leaving shortly to go to the airport. And then you'd have to believe that, to believe their theory. And then to make their theory work, they spend all this time talking about the plaintive wail of a dog, because they've got to make this as early as possible at 10:15. We know that that's not correct based upon the facts that you've heard. And to conclude, isn't it interesting that in all of the discussion yesterday by these two very excellent lawyers, they never once mentioned their coroner, Dr. Golden. He's another mysterious mystery witness they don't want to talk about. And when we come back this afternoon, let's talk about why the prosecution doesn't want you to know about Dr. Golden. Let's talk about when Ms. Clark says, well, you can't really fix the time of death here with any precision. We will have testimony from one of the leading pathologists in the United States, Michael Batten, who's also worked for the LA County District Attorney's Office, who's written a book about the John Belushi death. He was able to pinpoint the time of death to within 1 hour. And yet in this case, because the coroner was not called for 10 hours after these bodies were found, or 8 hours, and they got out there about 10 hours, violating the state law, we are precluded from pinpointing this. And they have to tell you that it's about a dog's wail when a man's life is at stake. We'll pick up after lunch, Your Honor.
Thank you, Mr. Cochran. All right, ladies and gentlemen, we will stand in recess for the jury until 1:30. Let me speak to counsel after the jury has departed. All right, let's clear the courtroom, please.
To portions of Mr. Cochran's...
Oh, hold on. There he is, right behind you.
Oh, there you are. I thought Mr. Cochran was hiding from me, and perhaps Willie should. Okay, no, I see you, Mr. Cochran. And, Your Honor, let me say this. I was about to say, you asked me to examine the record for instances of inappropriate remarks for an opening statement. I want to make the people's position absolutely clear this afternoon with regard to when objections are likely to be opposed, because I want to give Mr. Cochran fair notice. What we heard in large part this morning was not an opening statement, but could very well pass for argument, and if given an argument, would not be objectionable. But this morning, and as I stated to the court, I am reluctant in any case to interfere with opposing counsel's opening statement. It was with great restraint this morning that I did object to a number of clearly objectionable remarks made by Mr. Cochran. I will highlight those in just a few moments. However, Your Honor, what the people are seeking this afternoon is, first of all, an admonition to Mr. Cochran not to engage in argument in the guise of an opening statement. Secondly, with regard to various passages, which I will highlight and pinpoint for the court in just a moment, I'm going to be asking for a motion to strike, and in addition, an admonition to the jury to disregard such statements, because not only are they not evidence, but they are improper remarks for an opening statement, and the jury should be so advised. In addition, Your Honor, after I address the opening statement issue, I have an additional issue to raise with regard to discovery, because it appears we are about to revisit the events of Monday to some degree. I will begin, Your Honor, by stating generally many of Mr. Cochran's remarks were in the form of a rhetorical question. Many of his remarks were in the form of a personal attack on my colleagues, Ms. Clark and Mr. Darden. Such remarks are not fitting nor are they appropriate in an opening statement. Absolutely 100% not fitting, not appropriate. Let me give you just a few examples, and I have to cite to the reference that we were given off the disc that the court reporters were able to provide us. For instance, and I cite to what appears to be 0553 of this morning's transcript, where the defense argues that this case is about a rush to judgment and obsession to win at any cost by any means necessary. Your Honor, such a remark is fitting for argument, perhaps, not fitting for an opening statement. Clearly, that is outside the bounds. And again, Your Honor,
Well, Mr. Heitman, how does that compare to Mr. Darden's argument that the issue is that you have to establish the relationship and that the person who was guilty of this crime as a wife beater, batterer, controller, blah, blah, blah. Sounds like the same argument to me.
Well, does the court intend to make an equity call? I'm simply posing to the court things that I found to be objectionable.
Mr. Hodgman, here's the problem. Each side has to present what their theory of the case is. That involves some type of short explanation as to what that argument is going to be, and here's the evidence that's going to back up our theory of the case. That's opening statement.
And I understand that, Your Honor, and you stated a short.
Yes.
And I would submit to the court that based on what we heard this morning, that line got crossed very, very early on. I will continue.
Mr. Hodgman, let me do this. And please forgive me for interrupting you again, but we did discuss this also informally. My suggestion is that we do this. Because we have to break early for one of the jurors' medical appointments this afternoon, let you put these matters on the record when we conclude. Let me just caution at this time, Mr. Cochran, because I did mention to him that I felt that we were about to cross over the line into argument. You can tell him what the theory is. Mr. Hodgman, they are entitled to say that the prosecution has indicated this is their theory of the case and how they're going to proceed. And he's entitled to say this is what we're going to present to counter that. And he gets to explain how they get to do that. Now, I agree with you that evaluating it and saying that your case is trash for this reason or that reason, that gets into argument. I agree.
Okay.
All right. I will be more. My feeling was that the defense gave both Mr. Darden and Ms. Clark wide leeway in arguing and presenting their opening statements. All right.
But what the defense didn't do yesterday, Your Honor, was engage in rhetorical attacks upon opposing counsel, such as, why didn't Mr. Darden tell you about this yesterday? Why didn't Ms. Clark state something else yesterday?
I agree.
I
agree.
Argumentative and...
I agree.
Okay.
So what can be said is that the prosecution did not give you a complete picture. We're going to add this piece, and this piece for a clear picture. I think Mr. Cochran can phrase it that simply without referring to what the prosecution said.
Okay. We have additional language, and I raise this now, Your Honor. I will detail these objections more clearly at the time suggested by the court. But time and time again, Mr. Cochran stated this morning, and you would have to believe, and you would have to believe, and then you would have to believe time and time again, which again, Your Honor, this goes to argument, not to opening statement. Opening statement is supposed to be a recitation of the evidence that they expect to produce. And what you have clearly is argument. This is entirely inappropriate language, Your Honor.
Counsel, I've chosen to caution Mr. Cochran. I can tell by his response to me, he takes my caution seriously. Although I'm beginning to feel like the Rodney Dangerfield of judges these days. In fact, I'll have to call Barry Langberg later today. Mr. Cochran, you will take seriously my caution. All right.
Okay.
I just want to get the ball rolling today because we have a short court day.
And, Your Honor, and I agree with you, and the only reason I raise this now so that we can have appropriate opening statement this afternoon. Reference to hearsay, I lodged my objection this morning. I trust that the court and counsel understand the basis for that. I would point out as well that based upon the record produced thus far in this case, that reference to Mark Furman by name should not have been made. Based upon, no, I am referring to page 11479 of the record. This is Monday, January 23rd. The court states, I am precluding the defense from making mention of Detective Furman during the course of their opening statement solely on the basis of the fact of the late turning over of other statements of Kathleen Bell today. I thought that was pretty clear, Your Honor.
What happened later in the record, there was a request for clarification. I indicated that they could not mention Detective Furman in the context of Kathleen Bell. They could mention his participation in the investigation, however, and they could not, in opening statement, mention the Kathleen Bell aspect. There was a later clarification in the record.
Very well, Your Honor. We'll stand by that clarification. Then the last point I'll raise, and I will raise this in greater detail this afternoon. I know the court wants to move along. and that is the discovery issue. I can point out two names in particular this morning that were mentioned in the defense opening statement. Marianne Gertjes and Joe Stellini. These are names which are on the defense witness list, but the way Mr. Cochran referred to these witnesses this morning, it was evident that these witnesses have been interviewed, that there have to be statements outstanding someplace. Now, we have gone through this over the past couple days. The defense is supposed to disgorge witness statements to the people. And, Your Honor,
I have in my notes that these are items as well that I was concerned about. So
and
let's take...
I share the court's concern, Your Honor. I share the court's concern for this reason, because as we have stated throughout these proceedings, going back to late June and early July in municipal court and superior court.
Please forgive me. I recognize it as a discovery issue. We'll take it up as soon as we get the jurors on their way at 3:30. Then we'll have a full hour that we can sit and talk about this. I am concerned, and I do recognize it as a discovery issue, and I'm going to make further inquiry.
Very well, Your Honor. What I'm concerned about is the prospective aspect this afternoon when Mr. Cochran speaks. What else are we going to hear about? The people are being denied their right to a fair trial, Your Honor. That is what's occurring. This is surprise. The court sees the issue. The court sees and senses our concern. It is happening in opening statement, and the people have not received reciprocal discovery. I think that is evident to the court. The people are not getting their fair shot, Your Honor.
All right. All right, let's have the jurors, please.
Your Honor, may I send the witnesses home?
Mr. Cochran?
I think that's something we're cutting our time. I won't speed up more. We have taken 10 minutes of Mr. Cochran's time.
All right.
And what time would you like them back tomorrow?
9 o'clock. What did that mean, Mr. Darden?
My law clerk. Yeah.
All right, let the record reflect that we've been rejoined by all members of our jury. Be seated, ladies and gentlemen. Thank you. All right, ladies and gentlemen, at this time we will resume with Mr. Cochran's opening statement. Please remember that the opening statements by the attorneys are not evidence. Mr. Cochran.
Thank you very kindly, Your Honor. Good afternoon, ladies and gentlemen. When we broke this morning, we had just gotten to the point of discussing the coroner who previously testified in this matter, Dr. Golden, and I think I alluded to the fact that in the course of the opening statement yesterday, we didn't hear his name. And we expect that he will, in fact, be called in this case. Either if people don't call him, then we will. And I think that you will hear evidence to the effect that you can, in fact, determine the time of death with greater precision than you heard yesterday. That if one is qualified, one can look at the state of rigor mortis, the state of lividity of the body, state of the temperature of the body, and also the ambient temperature, use things like the stomach contents. In this case, there was a major problem. Dr. Golden's testimony is that he would place the time of death between 9 and 12 o'clock. Now, between 9 and 12 o'clock, you now have heard enough of the evidence to understand At 12 o'clock, Mr. Simpson was in the air. And at 9 o'clock, there'll be testimonies you've heard as to where he was at his house. So we have a problem with regard to trying to fix the time of death. And you heard the prosecution's theory yesterday about the time of death being about 10:15. You've heard from me this morning that the defense advances the theory that that's clearly wrong based upon the witnesses that you've heard. Now, with regard to Dr. Baden, who is our expert, and I should tell you a little bit about him. Dr. Michael Baden is a former forensic pathologist, the chief medical examiner for the city of New York. He resides in New York. As I said, he has worked for the L.A. County District Attorney's Office in the past. He's considered one of the foremost forensic pathologists in America. He came to, the evidence will be, he came to Los Angeles shortly after Mr. Simpson's return from Chicago, and in fact went to the L.A. County Coroner's Office that week, the week of June 13th. And it was after Dr. Michael Baden's conferences with Dr. Goldman and his superior, along with Dr. Baden's colleague, Dr. Barbara Wolf, that the Coroner's Office wrote a letter to Mr. Hodgman with an amendment to the coroner's report they'd filed. And I'd like at this time to turn our attention to the graphics. This is a letter that is directed to our colleague, Mr. William Hodgman. You'll see Mr. Hodgman there. And we'll proceed on.
D88. D88.
It'll become clearer.
Your Honor, excuse me. May we have? I have an objection to interpose. I wish to approach at sidebar, and I would like this image stricken from the screen for a moment. Very well, Your Honor. I withdraw the objection.
Thank you. All right, Mr. Harris.
As I was indicating to you, I think that this is a letter to Mr. Hodgman, and you can move to the next one, Mr. Harris.
That was D89, the highlight. That's D90.
It's an effort to make it clearer for you.
D91. D91A, this is D91B.
You can now see what's happened here, that the letter, the lines have been blown up so you can see them more clearly. And you'll be able to see them yourself. I don't have to read those, I don't think.
D92A. D92B. D93A.
Now this one, if I might stop for a moment, this would be one that's very important. I'd like to read this. The stomach contents of Ms. Nicole Brown Simpson were not saved. And you will hear testimony during the trial that if the proper procedure for any coroner's office in the United States, they wanted to determine with some accuracy the time of death would be to save the stomach contents. In this case, the coroner's office threw those stomach contents away. We will never have those. May proceed, Mr. Harris, please.
That was D93B. D94A. D94B.
This has to do with the mislabeling of a sample regarding Mr. Goldman. You may move on, Mr. Harris.
D95A. D95B.
It's another mislabeling or inadvertence. Move on, Mr. Harris, please.
D96A. D96B.
This has to do with a procedure which was violated by the coroner's office, which they acknowledged in this letter. After being separately dried, the panties and dress were wrapped together rather than separately. Mr. Harris, thank you.
D97A. D97B.
has to do with the media, the ever-present media. We'll move on.
98A, 98B.
It's an interesting one with regard to a recommendation that it would be desirable to perform a response team on complex cases by adding a pathologist, criminalist, and a coroner's photographer to the coroner's investigator and transport persons routinely assigned to respond.
99A, 99B.
This one called to your attention also that the coroner's office response team was not allowed access to the decedents by LAPD until approximately 10 hours after the LAPD's arrival at the scene. That will become, we think, important in the evidence, and we will share with you a transcript of a conversation between one of the detectives in charge when the call was first made and asking them not to come out at that time. Our experts will testify that if one wanted to determine the time of death, the coroner's office needs to be called as soon as possible to respond to the team. Mr. Harris, sir?
B100A, B100B.
Mr. Harris, you may move on.
B101A, B101B.
Mr. Harris?
B102A, B102B.
Fluoroscopy would have been desirable. Apparently it was not done in this case.
B103A, B103B.
Indication that photographic prints should have been made by the Sheriff's Department rather than LAPD, the coroner's office being an agency of the County of Los Angeles.
B104A, B104B.
All right, Mr. Harris?
B105A and B105B.
Mr. Harris?
B106A and B106B.
Thank you, Your Honor. Thank you, Mr. Harris. We finished that one. Now, ladies and gentlemen, as I indicated to you, what you've just seen and what we expect to be the evidence is that those are basically amendments to the coroner's report brought about after this conversation and meeting between the LA County coroner who did the autopsy here, Dr. Golden, his boss, Dr. Lakshmanan, and then our experts. Now, we expect that when Dr. Baden is called to testify in this case, he'll make a number of findings because he was there, was able to review all these records, and we expect the evidence to show, while we're talking about coroners, that he will testify that the injuries and bruises on Mr. Ronald Goldman's hands indicate that he had struck his assailant, and yet there was a fight, a major fight, prior to his death. That proper forensic procedures would preserve the stomach contents of the deceased, as I've indicated to you. That in this case, there was no rape or semen kit analysis performed, and we would expect that the expert would testify that a semen rape kit analysis is standard procedure for coroner's offices in the United States at this time in June of 1994. He will also testify, I believe, that closer to the time of death, one takes the temperature of a victim, their livor mortis and their rigor mortis, as the likelihood of an accurate result increases, and that's very important. He will say also, I believe, that the killings would have resulted in an enormous amount of loss of blood. And of course, you've seen that evidence of which would be expected to be on the perpetrator. They would have expected the person who committed these horrible crimes would be covered with blood. Dr. Baden, and along his colleague also Dr. Wolf, examined histology samples and pointed out to the coroner's office a bruising of the brain that Dr. Golden had missed. They pointed out some findings that their coroner's office had actually missed, and they advised them and let them know. There was in a supplemental report filed regarding that also. Dr. Baden as the expert will testify, that the L.A. County Coroner's Office violated their own procedures in performing these two autopsies. He will indicate further that the autopsy findings in this case are consistent with the struggle that resulted in hand-to-hand combat, that Mr. Goldman did in fact bleed profusely and he bled slowly, and that he was standing through most of this, and that in his opinion the perpetrator would be covered with Mr. Goldman's blood. Also, Dr. Baden will testify that there are blood drops on the back of Ms. Nicole Brown Simpson, and there were no swabs taken. In fact, when the body was moved and taken to the lab, those blood drops, which very well may have been of the perpetrator, were wiped off or washed off, never preserved. And so, what I expect the evidence to show through our testimony and through cross-examination, as I've indicated, that the coroner's investigators who came to that scene also didn't wear any covering over their shoes. That we expect you'll be able to see that this scene was tracked through and traipsed through by the coroner's people, just as it had been by the LAPD people. And at some time in this trial, we hope to have some graphic video evidence of that fact to you, so you can see for yourself. In short, what, from our standpoint, from the defense standpoint, in wanting a fair trial, being able to defend our clients, the actions of the coroner's office has obviously made everyone's job, and specifically the defense's job, much more difficult. That when the LAPD failed to notify the coroner's office for 10 hours in violating the state law, it made everybody's job more difficult. Dr. Goldman, if and when he testifies, as he testified at the preliminary hearing, when asked questions as to whether or not there could have been two knives used in these two killings, will indicate that some of the wounds on these two victims are consistent with a double-edged knife. Some are consistent with a single-edged knife or blade. So that it would be consistent that perhaps two knives were used. And I think that we can expect that from his testimony either by the people or by us if he is called to so testify. In addition to Dr. Michael Baden, we will have for you to testify Dr. Henry Lee, the foremost forensic crime scene analyst in America. He is head of the state of Connecticut lab. He'll be here to share with you his findings with regard to this crime scene and what took place at that crime scene and the contamination of the evidence thereof. Now, with regard to the opening statement yesterday, as I said, you were told that in this case the coroner's office couldn't do any better than 3 hours. And I think that with the evidence we've shown you, we're going to show that they could have done an awful lot better. And we'll have other cases to cite for that. I've covered with you this morning the question of the timeline. We'll talk about that at the very end again. Ms. Clark talks about a trail of blood where there is no trail. And we will expect to have evidence showing that whereas she told you yesterday, time and time again, that they were looking for matches to exclude, that what she did not tell you was that there are trails that lead toward innocence, and they were not pursued. Let me give you some examples based upon the evidence that I expect to produce in this trial. There is, and I'll go through this list for you. Expect the evidence to show that there was blood under Miss Nicole Brown Simpson's fingernails. It came back a type B in an EAP genetic marker. And that does not fit the genetic profile of Mr. Simpson, Mr. Goldman, or Miss Brown. Some other person. That there was blood found on Miss Nicole Brown Simpson's thigh. And that came back also for type B. There was, as you might imagine in this case, all kinds of evidence that's come forward, people who want to volunteer things. There was a knife found shortly after these killings. And the blood on one of the knives found also was this type B, similar to the blood that was found under Miss Nicole Brown Simpson's fingernails. You would expect that blood would be of the perpetrator since it's not hers. We will, in a short time, show you a graphic of several things in that connection. There were identifiable fingerprints which not match and don't match Mr. O.J. Simpson or any of the police officers there. And this becomes relevant, we think, because the contention of the prosecution is that one of the gloves was lost in this struggle, supposedly. There are identifiable palm prints. There's no match to Mr. O.J. Simpson. Our experts will testify there are different patterns of shoe imprints at this scene, indicating perhaps more than one person. No mention of that thus far. We expect that to be the testimony. There are no hairs on the Bundy glove that are matched to Mr. O.J. Simpson. There are negroid hairs on the knit cap at Bundy that do not match Mr. O.J. Simpson. But the prosecution has never, to this date, done any DNA tests, as far as we know, on the Bundy glove. Testing has been slow. That when the investigators arrived at the scene of these double murders, she talked to you about somebody named Detective Risky. Well, Risky may have been the officer who came there, but this case was assigned to Phillips and Furman. This was their case. This is West Los Angeles homicide. Phillips and Furman. That it was transferred from them because of the high-profile nature of the case to robbery homicide thereafter. But Phillips and Furman continue to play an active role in this case. You'll hear very, very little about an officer Risky. But one of the interesting things I think you'll find about this crime scene is the dearth or lack of any photographs, examination, or investigation inside that house. I don't think you'll find one photograph from inside that house. There will be some evidence that the officers who arrived at that scene, shortly after finding these bodies, found a partially melting cup of ice cream from Ben & Jerry's. We don't have that. I don't know that there were no pictures taken of it, so we don't have any way of seeing how much it was melted. We're precluded from that at this point. This was found near the back of the residence of the Bundy home. You heard a lot yesterday about blood drops at Bundy. Well, as you could tell, there are obviously thousands and thousands of drops of blood at that scene. Ms. Clark talked to you about 5 blood drops. But we expect the evidence to show that the blood drops that they found had very, very little DNA. And in the graphic soon I will try to demonstrate for you the amount of the DNA found in these blood drops, which meant that these blood drops, according to our experts, were either old or degraded, contaminated by people who collected them and tested them. And of course, the blood drops at Bundy are in an area where Mr. Simpson and his children have obviously been on many occasions. There were tire tracks in the back of the house which have not been matched to any of Mr. O.J. Simpson's vehicle. Now, one of the things that we expect to show during the course of this, our presentation of evidence, is that there was, in fact, a major struggle. And Mr. Goldman fought valiantly. He was apparently physically fit, 5'10" and 170 plus. He was stabbed a number of times, perhaps 30, and there was blood on his hands and arms. He had a number of defensive wounds. And the experts will testify that you would expect that the perpetrators, that Mr. Goldman's blood would be all over the perpetrator's clothes, hair, all over his body. In fact, he would be saturated with Mr. Goldman's blood. And of course, under the prosecution's theory, the perpetrator was driving that Bronco that night. And there's no evidence of Goldman's or Nicole Simpson's bloodstains inside that Bronco. of the amount that you would expect, given this situation, that the pattern of blood that they talked about yesterday, the small, very small pattern of blood in that vehicle, is very consistent with what I expect you will hear is a statement made by Mr. Simpson. Now, Ms. Clark went on yesterday and said that with regard to the DNA evidence, she talked a little bit about DNA. She didn't talk about or make a distinction for you between the RFLP, the restriction fragment length polymorphism, or the polymerase chain reaction, the PCR, of which our expert basically invented it. But I think what you'll find is this is very, very sensitive evidence that is then Xeroxed up, molecular Xeroxing, and we'll talk about that a little more later. We think the evidence will show that the pattern before I tell you that, I think the evidence will also show that on the steering column of the Bronco, item number 29, the people's exhibits, I don't think you were told this yesterday, that they did not talk about a DNA mixture consistent with, not necessarily a match, consistent with Mr. Simpson and someone other than Nicole or Ronald Goldman, some other person. That with regard to Rockingham, Mr. Simpson's residence, again, I expect there will be testimony that Mr. Simpson did in fact cut his finger in some place where I'm pointing now, near the end of this middle finger. And he so told the police that evening, on January 13th, and that he went out, he did it either as he's about to leave or whatever, he went out to the Bronco to get his cellular phone. That what I think you will find and what I think the evidence will show is that the reason there was no blood coming up the stairs, and this carpet in this house, I think you'll find the evidence will show, is largely white, largely very light. If you have a jury view, you'll be able to see it for yourself. You didn't find any blood other than what you saw outside and just in that entryway. And I think you'll find that leads toward the kitchen. And there will undoubtedly be testimony with regard to that injury, if any, occurring before he ever left for Chicago. There will be, as I understand the evidence, no trace of blood on the white carpet, upstairs or up on the stairs or upstairs. No trace of blood on the white carpet from any bloody shoes. No trace of blood on the white carpet from any bloody pants or shirts. And no trace of blood on this white carpet from any bloody socks. The evidence will show that in an effort to find any evidence, not to exclude, but to include Mr. Simpson, they searched everywhere in the area in Los Angeles. They searched in Chicago. They searched everywhere they possibly could think. And they did not find any weapon or any clothes because Mr. Simpson, the evidence will show, did not have them. They took apart traps and pipes from his sink, showers and plumbing, and searched everywhere for these various things. The evidence will also show that with regard to Miss Nicole Brown Simpson.
No objection.
Mr. Hodgman?
Yes, Your Honor, may we approach?
All right.
I should point out that the people in their investigation did in fact check the sink area and the shower area and some areas in the bathroom, for the bathroom floor, for areas for an indication there may be blood in those areas. some of those tests came back positive. There will be testimony. There will be testimony with regard to this entire area as to those tests and what other things will test positive for. The court will, at the appropriate time, allow this to be discussed. Now,
Proceed.
thank you. With regard to Ms. Nicole Brown Simpson, which I was about to talk about, the testimony, we believe the evidence will be that because of the nature of her injuries, a lot of blood came forth, so that the perpetrator would in all likelihood be covered and soaked again with her blood. We think this will become important again when you determine the absence or lack of blood, certainly with regard to Mr. Simpson, not perhaps regarding the perpetrators of this offense. Ms. Clark yesterday talked about a mysterious disappearing black bag. We expect there will be videos in this case that the black bag I presume she was talking about was Mr. Simpson brought back with him from Chicago. It can be seen clearly with that video, with that black bag. And I believe it was in police custody, certainly at one point. I know they had it in their custody. And so it didn't seem to us that's a big mystery, but we'll have to look at the evidence as it develops. But we're not aware of any missing black bag that Mr. Simpson has or whatever. So looking at the evidence at Rockingham, and then there's this Rockingham glove that's supposedly found in an area that you saw some pictures about yesterday. Mr. Simpson's home. It's a very, very narrow pathway on the side of his house. You saw the pictures of this glove, which was on top of some leaves. There will be no testimony, as I understand it, about any blood drops leading to and from that. But as I expect the evidence will show, there's a fence right up there close by this blood drop. This pathway leads basically to a backyard area that's kind of basically enclosed. I think there's maybe a gate on one side. I think the evidence will show if somebody wanted to come in the house on that side, and you'll see this when you go out there, there are at least 2 doors on that side that somebody could go right inside the house without climbing over a fence or anything of that nature. You will see the evidence, and again, you will be the one who can help make those facts. But with regard to this glove, which was, and then again, I think that, let me try to set the record straight for you. This glove was not found by them or the officers or whatever. This glove was found by Detective Furman. He found it, and he then individually took these other officers back there supposedly to see it. They had supposedly brought a photographer over there to take pictures of it. Although you didn't hear that yesterday, those are the facts as I understand them. As I said, there's no blood trail to these leaves. The leaves don't appear to be disturbed. There's no evidence of any hairs, fibers on this fence. And there was testimony, and will be testimony, I believe, that there were cobwebs in this area beyond this glove. Presumably, one could infer that nobody had been back there for some period of time and knocked those cobwebs down. With regard to this glove, there's also on this glove a Caucasian hair on this glove that does not match the hair of either Nicole Brown Simpson or Ronald Goldman. And Ms. Clark told you yesterday that how samples are collected and who collects them are unimportant. I alluded to this briefly, but we think that the evidence will show that the Nobel Peace Prize winner who invented this technology will tell you it is of paramount importance how this is collected because of the sensitive nature, how very small. You can't even see some of these samples. You'll hear that testimony from Dr. Carrie Mullis. You will also hear testimony from Dr. John Gertis, another leading expert from Denver, who we expect will come to testify. It seems to me that any attempt to, in the evidence, to make it seem as though PCR technology and DNA and RFLP is easy to understand, it's very complex. I think from both sides, we want to do everything we can to make this as clear as possible. I think that you will hear testimony, and I ask you, of course, to keep an open mind as you hear the experts on both sides, and I think you'll get a clear picture of this particular evidence. I mentioned before this crime scene and the number of people who were allowed to walk through there, many with just their shoes on, walking right through the blood, some who had those little booties on, some had gloves, some didn't have gloves, picking up the evidence. This will become very relevant and important to you as you hear from the experts about the contamination aspect of this and what it means, how easy it is, a sneeze, a touch, whatever, for this evidence to become contaminated. You'll hear about this new technology, but you'll hear also that the expert who invented it doesn't believe it's being properly and appropriately applied, and is not ready, perhaps, in a forensic sense to be used. That is, to be used at a crime scene and then brought to court. When Ms. Clark talked to you yesterday about the medical uses of it, she talked about amniocentesis, and that was nice. But in amniocentesis, you have known individuals. You know who the father and the mother are. At least you better know who they are. I was hoping that when you take the fluid, you know that. In a lab, a clean setting, it's not like a crime scene or whatever, you will hear the distinction. As I said before, this 21st century cyberspace technology used by people poorly trained in the field. We're using like 19th century techniques to collect it. Ms. Clark mentioned to us yesterday about Jurassic Park. It's not a movie. It's just not, you can't, and it would be fantasy to think that you could take and make dinosaurs with DNA. Nobody's done that. That's a movie. It's not real life. She talked to us about the czars in Russia and that sort of thing. Well, it's one thing to look for bones. There is a technology that you hear about was not used in this case. It's a different technology altogether, some kind of sequential DNA testing, mitochondrial, and I won't bore you with the term. That's not used, but the experts will tell you that's not relevant to the proceedings here, what was done here. So with regard to the claim that every effort was made to exclude Mr. Simpson, we think the evidence will show that that's not what happened in this case. We have to keep an open mind. We think the evidence will show that when test results pointed away from Mr. Simpson, they concluded that something must be wrong with the test. Our experts will tell you that there are huge interpretation problems with many of the tests performed in this case. This is particularly true where there are mixed samples containing blood or other biological material from more than one person. We expect to show that the results of some of the tests in this case are so ambiguous that two different scientists will come to two different conclusions with the same results. As I said earlier, given Mr. Simpson's statement to the police, the evidence of anything, any blood in the Bronco is far more consistent, we believe the evidence will show, with Mr. Simpson's innocence than any guilt. And the fact that there's almost no blood of anyone else, if any, in that Bronco is just the opposite of what you'd expect if somebody committed a crime and used that vehicle as a means of transportation. Now, to conclude then with regard to my discussion of Ms. Clark's opening statement, a number of things were said to you yesterday, and Judge Ito at the end of the day asked you to keep an open mind. As I thought about this case last night, I was concerned, just for a moment, as I thought about, well, we didn't get a chance to talk to them yet, through circumstances beyond our control. But what quickly came to my mind was the fact that the jury that we've tried to work and pick since September has been so patient, would keep an open mind. And I'm sure you've done that. That's all we're asking. But not only from last night to today, but until you hear the end of the case. Because you remember, and part of what I'm saying to you today, is that the case won't be over till you've heard all the evidence and the summations by the lawyers. And all of you have said that would be unfair to make up your mind before that. And I think both sides would agree with that. So in her conclusion yesterday, she'd indicated that something about it was devastating, proof of something other, if you remember. It seems to me, as I thought about what she said, that the fact that there is no blood where there should be blood is devastating evidence of innocence. And we'll be talking more about this, that the fact that blood voluntarily given by a defendant mysteriously disappears when it should be there is devastating evidence that something is wrong. And finally, it seems to me that the fact that blood mysteriously appears on vital pieces of evidence, and it's predicted what the results will be regarding DNA when that evidence is still in the police lab, is devastating evidence of something far more sinister. Now let's turn our attention again, if we could, to the laser disc showings. Let me start this part of the presentation quickly by showing you again some trails that lead to innocence that weren't pursued by the prosecution team. And, Your Honor, I'll be moving ahead, and we'll call out the number. Before we do that, Mr. Douglas, can you retrieve the envelope? Might give you some discovery.
Yes, with the court reporter, please. All right, thank you, Madam Reporter. Mr. Cochran, you may continue.
Thank you very kindly, Your Honor. I think we were, just before we get to the disc showings, I just would indicate to you that I expect there'll be evidence, as I've indicated to you somewhat already. There was an intensive search in Mr. Simpson's home looking for any kind of a weapon, presumably a knife of any kind. And I think that during the course of the trial, there'll be evidence that will become very relevant to you with regard to this entire area and the people's theory with regard to knives. Now, we've now moved on, Your Honor, to a report dealing with the fingernail clippings.
B1A.
I had talked to you earlier about this analyzed evidence report, and this is the actual report of the substance found under Miss Nicole Brown Simpson's fingernails.
That was B1B. That is B2C. I'm sorry, B1C.
What 84A and 84B, I think the 18A is a typo. Could not have come from Nicole Brown Simpson, Ronald Goldman, or O.J. Simpson, as I indicated to you earlier. Mr. Harris?
B2A, and we have to
There is the next photograph is coming up. May I have just 1 second?
Do you need the reporter? All right. Thank you, counsel.
Thank you, Your Honor. Since there's a record, Your Honor, Mr. Douglas has indicated to me I need to read the graphics into the record. I'm not sure that our court reporter is getting all these. It's item 84A and 84B. It says 18A, which I understand is a typo, could not have come from, quote, Nicole Brown Simpson, Ronald Goldman, or O.J. Simpson. Now, there's another, the next one coming up, I was going to ask Ms. Clark. Your Honor, you may want to hit your kill switch on this next one, just briefly.
All right.
This next photograph is what I alluded to earlier as the blood on Miss Nicole Brown Simpson's back, and it's an indication that testimony is from our expert that this blood on her back in that position was, in fact, never preserved, neither by the LAPD nor the coroner's office, and was, in fact, wiped off and never preserved or saved. Thank you, Mr. Harris. To conclude, then, Ms. Clark's opening statement, I'd like now to move to a discussion of what I expect the evidence to show vis-a-vis the defense in this matter. You may have asked yourself, in hearing this evidence this far, who then is O.J. Simpson? That's an answer that will come, hopefully, during the course of this trial. I can tell you that the evidence will show that he is a 47-year-old man, father of 4. In many respects, he's the living embodiment of the American dream. I think that you will hear testimony and evidence about certain other things you don't know about O.J. Simpson that may become relevant during these proceedings. There will be testimony that O.J. Simpson suffers with chronic rheumatoid arthritis. He's one of the leading rheumatoid arthritis doctors in the country, and that when he's in remission, he can function fairly well, but when it's an acute phase, he has great trouble functioning. We expect there will be testimony that on the date of June 12th, Mr. Simpson was involved in the acute phase of his rheumatoid arthritis. And on that date, after he had played golf, the problems with his hands were so severe he could not shuffle the cards where he played gin rummy at the country club thereafter. We expect that will be, the evidence will be adduced. You will hear from several of his doctors who are on our witness list to further buttress the fact that he was in an acute phase of this rheumatoid arthritis shortly after he came into custody. Mr. Simpson had surgery in which some lymph nodes were removed. These lymph nodes were caused by the rheumatoid arthritis, contain white blood cells. In addition to that, I alluded to the fact earlier that he was perhaps the greatest running back in the history of the NFL, with all kinds of records. But you pay a price, and the evidence will talk about that price that he paid. On his left knee, he's had 4 surgeries. We expect you'll hear from his doctor about the effect of those 4 surgeries, about the effect of what he has in addition to the chronic or acute rheumatoid arthritis. He has osteoarthritis in his legs. The evidence will be he suffers with rheumatoid arthritis in both of his wrists. And so, things are not as they always seem. And as you see him sitting there now, he does, in fact, have problems with movement. There will be testimony that he plays golf. that he can no longer play tennis, that when he plays golf, he always has to use a golf court. Can't walk 18 holes. We expect there'll be testimony that he's perhaps one of the only few people in the world who's able to use a golf court at Pebble Beach because his doctor had to write such a letter. And so, I'd like to demonstrate that for you, the extent of his knees, and say to you that what no NFL, National Football League defense could do, Mother Nature and Father Time have taken their toll. Doesn't mean he can't move around, but I think there'll be evidence of the limitations now imposed upon him by virtue of his career, by virtue of this disease that he suffers. And I'd like, at this point, to have Mr. Simpson come over to the jury so I can demonstrate the problem with his knees. If I could, with Ms. Deputy McNair.
All right, ladies and gentlemen in the back row, if you want to stand up, feel free to do so.
Well, for the record, so the court can't see it, but Mr. Simpson is demonstrating for the jurors his left knee, and I think there's an indication that there are scars going up and down, sideways, and there's one behind, I think, and one in the front. I think there's an indication that he's had at least 4 surgeries on that particular knee. While you are here, Mr. Simpson, I would like for him, Your Honor, to be able to show his, not your wrist, but his middle finger of his left hand, Your Honor.
Yes.
Correct. I can't mark this as an exhibit, but I can at least do what the court will allow me to do. I want to show his middle finger of his left hand.
Let me caution the photographers to use extreme caution.
Yes, Your Honor. Thank you. Thank you.
All right, thank you, counsel.
In addition to what you've just seen with regard to his left knee and the condition I told you about, Mr. Simpson is dyslexic. He suffered with dyslexia all of his life. And you know what that is, where he tends to, when reading, things get reversed and transposed and backwards. Despite all of that, as I've said, you see what he's done with his life. I think the next area we'll deal with, and Mr. Douglas will put the diagrams up. You've heard and will hear testimony that on the evening of June 12, 1994, Mr. Simpson had a trip planned to Chicago, Illinois on American Airlines. The plane was due to leave at about 11:45, and in fact, it did leave around that time. Mr. Simpson got to the airport, got on the plane. Yeah, Coach. And what we seek to illustrate here is his demeanor and all the people on the plane and their relevance to this particular case. We expect there will be testimony that he was one of the last people to board the plane that particular evening, as he headed east to go to Chicago. That he took a seat, and he was fortunate enough to be sitting in first class, and that sitting very close to him was a young man by the name of Steve Valerie, whom I believe you will hear testimony. Steve Valerie was very impressed that he was sitting next to O.J. Simpson. So we had occasion to watch Mr. O.J. Simpson, watch his hands. He'll tell you he didn't see any major cuts on his hands or anything of that nature, but he observed his demeanor, observed how he acted, observed how he handled himself during that particular time. That there was a man on this flight by the name of Howard Bingham, a man famous in his own right. He's Muhammad Ali's personal photographer. He lives here in Los Angeles. And Howard Bingham was on his way to see Muhammad Ali. He left his seat back here, He walked up, had a conversation with Mr. O.J. Simpson. He too will come in and tell you how Mr. Simpson appeared on June 12, 1994, 11:45 to the time that flight got there, Chicago. And there are others, as you might imagine, who've seen him. Particular interest is there's a captain of this flight, Captain Wayne Stansfield. Found out that O.J. Simpson was flying to Chicago. And he came out of the cockpit. You know, you always worry when you see the pilot come out. But I think that presumably means there are a couple others who can fly the plane. So he came out, and he got Mr. O.J. Simpson's autograph on the flight log. So he had a chance to see his hands, had a chance to observe him. He signed autographs as he got out of the limousine for the sky caps. Remember, he'd gotten some money so he could give the sky caps some money. That would be testimony that he had $10 or whatever. The sky cap had no change, and he gave him that, of course. And you'll hear about this flight. You'll hear about this man's demeanor. Hear about how he handled himself, how people watched him during this period of time. Mr. Valerie especially was looking at his hands because he thought that O.J. Simpson would have a championship ring on his hands. So he had occasion to look at him, watch him, observe him, as did Howard Bingham, who knew him before this time, as did the pilot, and as did all the other people who came in contact with him. Thank you, Mr. Douglas. The next graphic, which we think will be relevant to you in the course of the presentation of the evidence. This time, as you can see from the graphic, Your Honor, we're not getting the numbers covered.
The first one was 203, this is 204.
Referring to number 204, and you can see the legend is we're going from east to west this time. This is after the evidence will show Mr. Simpson has been told that his ex-wife has been found murdered. You will see the difference in this man's demeanor and how he reacted and how he handled himself. From the time he got that call from Detective Phillips, found out his ex-wife had been murdered, and how he reacted, what he said, his concern about his children, how he called and tried to get the first flight out of Chicago, how they had a flight too late for him at 10 o'clock or something. He insisted on an earlier flight. He wanted to come directly back to Los Angeles as soon as possible after this conversation. He made calls while on the way back from Chicago to Los Angeles to try and find out what had happened. And we'll be calling certainly more than one witness on that flight. It's very interesting. Seated right next to O.J. Simpson on this flight back is a lawyer by the name of Mark Partridge. Mark Partridge sat with him the entire time. He will come in here, he's a lawyer in Chicago, and tell you about this man's demeanor. One of the interesting things about this, I think you'll find, is that whereas Mr. Simpson had no cuts on his hand, in the knuckle area that anybody saw that we know of going, when he came back, he had a cut, which you just saw, remnants on his knuckle, in the middle finger. Mr. Partridge saw that. There will be testimony that in the hotel room in Chicago, there was a broken glass, shards of glass in that hotel room. There was blood associated with that glass and with the towel therein. His whole demeanor, as you might expect, had changed. He suffered a terrible loss. He took the first flight back from Chicago here. We think that Mark Partridge, along with other people who may be called, will be very, very relevant in the course of this case. Now, as depressed as he was, people who came in contact with him still didn't know about his tragedy. People would still come up and ask him for autographs during this period of time. But he did get back to Los Angeles sometime that day, and he went, we think the evidence will show, directly to his home on Rockingham, where he was first of all placed in handcuffs. Then they were taken off. And then was asked if he wanted to come downtown and talk to the police. Maybe not asked, told. He should come downtown and talk to the detectives in this case, Van Adder and Lang. He voluntarily did that. He had a lawyer there by the name of Howard Weitzman, one of our more prominent lawyers here in Los Angeles. He had his business lawyer, Skip Tabb. But he came home. There were no police at the airport. He came back home. He went downtown. They talked to him in the car on the way downtown. And when they got downtown,
Excuse me, Your Honor, I think the court knows the objection I have in mind. If not, I'd be happy to approach.
you didn't know what I'm going to say.
I don't know, well, counsel wanted it around a little bit too. We can have an offer of proof. My objection, no.
Why don't you approach without the reporter, please? Thank you, counsel. Mr. Cochran.
Thank you very kindly, Your Honor. Sorry for the interruption again. When Mr. O.J. Simpson, as I said, returned home at his residence, he went downtown with the police detectives. He had two lawyers who followed him downtown. Howard Weitzman, noted lawyer, and his business lawyer, Mr. Skip Tabb. We think the evidence will show that Mr. Simpson got downtown. His two lawyers will testify, or at least one of them will, that he was told, they were told by the police that they could not be present when Mr. Simpson was interviewed. And Mr. Simpson, and that there would be, and the evidence will be, if that happened, that's wrong, it would be a violation. But Mr. Simpson went ahead and talked to the police without discussing any contents with his lawyers, not in the room, and away. They went someplace else till this interview, some 33 minutes, had concluded. We expect that's what the evidence will show in that regard. In this connection, we expect there will be testimony and evidence from a number of witnesses of things that happened that week, not the least of which will be a gentleman by the name of Al Collings. We expect that Mr. Collings, a very dear friend of Mr. Simpson's, will testify, along with others, about the events of the date of June 17th, 1994. The low-speed pursuit that you all indicate you've heard so much about. We expect there'll be testimony about that when Mr. Collings spoke to the police, they were headed north on the 405 back to Mr. Simpson's home, that on that particular date, among other things, Mr. Simpson had been heavily medicated after the funeral that week, that he wrote some letters, that he called his first wife, Marguerite Simpson, among others, and his family members, and that he insisted to those who would listen that the events of the week
Not offered by the adverse party, counsel.
let me rephrase that. He had a number of conversations with people who were very close to him that week. And I expect the evidence will be that you will hear what he was saying, what his state of mind was, what triggered this low-speed pursuit. Expect you'll hear from Mr. Collings. They'd gone down to Orange County to his wife's grave. And that, when the police encountered him, heading north on the 405, they were heading back to the Rockingham address, and that he, in fact, ended up there. One of the things that I would like now to turn is a photograph I'd like to alert counsel to. next exhibit is a photograph of Mr. Ronald Goldman's hand. And you will see, and you've heard, I've indicated to you that there'll be expert testimony from forensic pathologists. If the bruises there are an indication that Mr. Goldman's hand and fist came in contact with the perpetrator, if there was blunt force trauma, and that he was able to strike his assailant. There will be other testimony with regard to other wounds on his hand. I think that's relevant because I would like next to have Mr. Harris move to the next photographs. What's the number on that one? D13. When Mr. Simpson returned to Los Angeles on June 13th, the pictures you're about to see now are pictures taken of his body on June 15th, 1994, and June 17th. These first ones are from June 15th, which was a Wednesday. It's Mr. Simpson, and I want you, hold that a minute, Mr. Harris. I want you to look at Mr. Simpson's face in this picture. Rather than looking more morose, look at his face in the photograph with his daughter Sydney. What's the number? Number 200. And this photograph here. We expect that the evidence will be there are no bruises on his face or on his body. This picture was taken on June 15, 1994. Mr. Harris, will you go to the next photograph, please?
D15, D16 is coming up.
D16, another shot of Mr. Simpson's body.
D18, D19, D20, D21,
The right arm,
D22,
the right hand, and part of the forearm.
D23,
It's the left hand.
D24, D25,
Now this photograph, the testimony will be, this photograph was taken on Friday, June 17th, and we think that the indication that blood had been taken from him that day by one of his doctors I talked to you about, his arthritic doctor, and his other doctor, his osteo arthritic doctor, and also his orthopod had taken blood from him that day. This is a picture of his right arm. This is Mr. Simpson's back.
26,
Mr. Simpson's
27.
face and teeth.
D28,
It's a picture of, a revealing picture of Mr. Simpson, however, but to show his entire body.
D29,
Mr. Simpson's hand. And just on D30, you can see that kind of circular mark there, which you saw, a faint mark there. We expect there'll be testimony that with regard to that particular mark there on his middle finger, that there will be testimony among the doctors on our witness list that is in no way a knife cut, that is more consistent with some glass or some shards of glass having made that particular cut.
D31, D32, D33, D34, D35.
Is that it? All right. Now, to conclude this particular portion of our discussion, we expect there will be other evidence of demeanor and pictures. We expect that, although we've heard the police wanted to exclude Mr. Simpson, that when they talk to him on the 12th, I don't think you'll see any pictures taken of his body, except the one picture she showed you yesterday of his hand. But we wanted you to know that there are other pictures. As part of our part of the case, we have these pictures. We wanted to share them with you. Now, Your Honor, I'm now about to turn my attention to the LAPD and its lab. It may be, I do not now believe with all the interruptions, I'm going to be able to finish today as much as I wanted to, so that whatever Your Honor's pleasure is, this next portion is fairly lengthy.
Well, counsel, I leave it to your professional discretion. Do you think this is an appropriate breaking point?
Yes, let me just take a look, Your Honor. I think that it is. I'd like to make just a couple statements. I think that it is, if I may.
Proceed.
Thank you very kindly, Your Honor. Sorry, I'm not going to be able to finish today, ladies and gentlemen, but you can understand the importance of this case to both sides. We've had a number of interruptions, and I'm sorry it's taken longer. But I'm sure you'd expect nothing less from either side of the lawyers from either side in this case. Tomorrow we'll come back and we will start talking about the police investigation. We'll go through some charts, which hopefully will make the whole subject of DNA a little less complex and confusing. We will talk about the so-called evidence flow in this case. One of the factors, and we'll start at the very beginning of the police investigation and work our way through, to determine what they did and how they did it and how it impacts upon this case. The important piece of information that we think the evidence will show, however, is that all of this evidence collected, whether at Bundy or Rockingham or wherever, went through the LAPD lab. And we expect to introduce evidence that from their own records, that laboratory is a cesspool of contamination. Not up to speed, not up to standard. We think we can conclusively indicate that during the course of the testimony in this case. Thank you very much, and I would ask you to keep an open mind until tomorrow, till we have a chance to finish. Thank you very much.
All right, ladies and gentlemen, as far as the jury is concerned, then we're going to take our recess for the afternoon. Please remember my admonition to you: don't discuss the case amongst yourselves, form any opinions about the case, don't talk to anybody about the case, nor allow yourself to be approached or spoken to with regard to the case. And we will resume again, hopefully with the conclusion of the opening statements tomorrow morning at 9 o'clock. As soon as the opening statements have been concluded, I anticipate that we will be calling the first witnesses tomorrow morning within moments after the conclusion of the opening statements. We'll just take a recess long enough to take down the easels and things, and then we'll start with the actual presentation of the witnesses' testimony for you tomorrow. All right, have a pleasant evening, and ladies and gentlemen, counsel, let me ask you to stay behind because we need to put a few things on the record before we conclude for the afternoon. All right? Let's clear the courtroom.
On. So it's really used.
So you're saying this
it's
is
used for impeachment.
This is coming in as impeachment after the prosecution has presented its searching officers?
Yes.
Mr. Hodgman, as to that item?
Your Honor, I share the court's reaction in terms of rolling the eyes. First of all, there is only one report which has been available to the prosecution. The court knows that. I double-checked as recently as 2 weeks ago just to be sure and obtain another copy.
All right, I was mistaken in my assumption that that had been turned over, because I recall some report having been turned over to you with regard to that, so I had assumed that that was everything. My mistake.
The problem is, Your Honor, is we have what occurred this afternoon, and that is very, very prejudicial to the people. I don't think I need to explain that any further in terms of that demonstration for dramatic effect and prejudicial effect to the people. We're going to ask that the court admonish the jury to disregard that. We ask that any reference to that be stricken. We ask that the defense not be allowed to produce or utilize that item in any fashion whatsoever. And, Your Honor, we will be asking, in addition, for a little bit of time to think of other discussion. Excuse me. I need to slow down myself a little bit, Your Honor. Give me just a moment. Yesterday, or the other day, the court said it had to take a deep breath. Allow me to take one, too.
I took a deep breath, decided it's time I should take a recess, and then I decided I should go home. And then,
Yeah.
I don't know, some of the pundits criticized me for taking time on making up my mind. I don't know.
Well,
Mr.
Your Honor,
Hodgman.
the court is absolutely accurate in the sense that we have some discovery items of concern and that deserve discussion this afternoon. In counsel's opening statement today, there has been reference, and I have a laundry list here, but there has been reference to...
Okay, well, let's deal with them one at a time. I have a number of witnesses that were mentioned that I have some concern about, but let's deal with the envelope, its contents, and the reports relating to it. What is your response specifically to Mr. Shapiro's argument that I agree with you. I'm concerned about its use, the envelope's use, during the course of opening statement. But what is your response to Mr. Shapiro's argument that since it is going to be presented as an impeachment item, and unfortunately, well, I mean, you know from the report what the item is, from Dr. Lee and Dr. Sugiyama's report as to what the item is, so that's not a mystery.
We know what the item is, Your Honor, but as far as the stated purpose, I mean, that is something that I believe occurred on shifting sands this afternoon. We're going to ask for a hearing with regard to any utilization of the envelope, the contents of the envelope, and we certainly ask for what I've requested thus far, that is an admonition to the
All right,
jury.
well, let me ask you this, Mr. Hodgman. The issue, just as far as the envelope and its contents, you know what it is. You know that it was an item sought by the police, by the investigating officers in their search warrant, and that they did not, in fact, recover it.
Your Honor, we don't know the circumstances of the recovery
Well,
of that item.
I know.
And to state...
No, Mr. Hodgman, I'm stating known fact. You know what is in the envelope from the report from the two doctors, or the criminalist and the doctor. You know that it was an item that was originally sought, or something similar to it was sought in a search warrant, correct?
I know that items like that, that particular item, Your Honor, I don't know the source, I don't know the circumstances
let's
of the
assume-
recovery.
Let's assume we're talking about the same thing.
I can't make that assumption, Your Honor. I don't know until
All right.
we
No,
get
no.
discovery of the circumstances of the recovery of that item. I mean, we are completely in the dark. And what, Your Honor, again, I'm going to go back
No,
to the
here's
basic...
the point. The point, though, is they're saying they don't have to disclose it because it's impeachment evidence, that it's going to come during the course of the cross-examination of the police officers that you're going to call serving the search warrant and seizing evidence. What's your response to that?
My response, Your Honor, is that...
That's the issue.
It has been disclosed. We want an opportunity to be able to have a hearing on this and litigate it. My position right now is that item should be simply suppressed. Now, we have a stated purpose from counsel this afternoon, but that should not have been forthcoming in an opening statement. Not at all, Your Honor.
Mr. Shapiro, I'm concerned, though, that you've sort of waived certain confidentiality as to what it is by its use or its attempted use in opening statement. Wouldn't you agree?
No, Your Honor, I respectfully disagree. There was never any intention to open it. The only intention was to tell the jury something very simply, that the police have not done a proper job in investigating this case. And it started at the beginning and it went to the end. And even though they had two search warrants to search a location and to look for a particular item, as directed by two judges, that their incompetence was so gross that they overlooked a potential key item of evidence, and we will point that out as impeaching evidence of the officers who were in charge of this search. We were not going to open it. We were not going to describe its contents. We were not going to mention where it came from. We were simply going to say that the evidence will show that the Los Angeles Police Department had directions from two judges to look for something.
All right, well, the value in not having to disclose something that you're going to use for impeachment purposes is obvious. The problem is you've created a problem by bringing the envelope out. I agree Mr. Hodgman's entitled to a hearing before the item is actually opened, and we will have that hearing at the time that the defense intends to present that, prior to that.
we would also ask the court to inquire what grounds there are for the people to suppress an item of impeachment.
Well, they've asked for a hearing. I'm
On what
indicating-
grounds?
Well, I have no idea. I'm sure between now and 2 months from now, when it's actually presented.
No, it may be presented as early as tomorrow, depending on what witnesses they call.
Could be. We'll see. Well, prior to its presentation, we will hold a hearing outside of the presence of the jury as to what it is. They're entitled to know what it is before you use it, but not to prepare their witnesses.
They know what it is.
Well, I know what
They've
it
already
is, yeah.
stated that.
Okay.
All right,
You're-
now, as to the name, so the issue will remain unresolved until the matter actually comes up for presentation, because I think that's the time to litigate that issue. But you're on notice that it's there.
We're on notice that it's there, but we are still completely in the dark. The people are completely in the dark as to the circumstances of the recovery. We may know what it is, Your Honor, but counsel has information and is making allusions
Well-
this afternoon.
Mr. Hodgman, let me suggest you do this, though. My understanding of the law of impeachment is they're not required to disclose it until they want to use it, if it's impeachment evidence. If you have some evidence out of the law of discovery that's contrary to that, let me know tomorrow. If you got some cases to the contrary, let me know.
Also, I think perhaps it might help Mr. Hodgman if this item was not recovered by us, but it was recovered by a retired judge at the court's direction.
Whose behalf?
We-
Dr.
you-
Judgment Collector?
Okay. Your Honor, we are still unaware of the circumstances of where, when this item was recovered. We don't know. The people have never known. Counsel apparently knows. And it was, that whole arrangement
I
was
know.
done at the request of
Mr.
the
Hodgman,
defense.
Mr. Hodgman, it's obviously a discovery issue. The question is, are you entitled to know about their impeachment evidence before they present it, until just before they present it? My reading of the law of discovery is the answer to that question is no, if it's impeachment. If you have some authority to the contrary, let me know tomorrow. All right, I've directed Mr. Cochran, I gave the envelope back to Mrs. Robertson, directed him not to use it in his opening statement. So that's where we stand.
And with
Okay.
regard to that, Your Honor, again, we repeat our request for an
No,
admonition to the
you don't-
jury.
You don't need to repeat it. Thank you.
Very well.
Okay, let's go
Witnesses.
to I'm sorry, Mr. Cochran, you're going to have to spell his name for me.
Which one, Your Honor?
Gotchas,
Is it Marion Gerchas? I
Gerchas.
think it's Marion, it's spelled Gerchas.
When you bring up something like that, the court reporter would be thrilled if you spelled it. All right, thank you. Mr. Douglas, are you going to address these discovery issues regarding witnesses?
I'm going to try, Your Honor.
All right.
The court is well aware that we have been working diligently in this manner. The court is equally aware that the work in this case has been divided among a couple of offices and investigators, etc. It perhaps is regrettable that I stand before this court that we have not coordinated all of our defense efforts as well as I would have liked before this point. I say that because, Your Honor, I have some documents that I do intend to give over to the people. As the court has encouraged both last night and before, I have had a law clerk working from mid-morning on yesterday, preparing to provide documents and any witness statements on this matter.
One of the items I forgot to do this morning was to ask for your report this morning.
And that is what I'm doing right now, Your Honor.
All right, my mistake.
By way of background, just so that I could lend some scope to what our efforts have involved, I have in my own office 16 notebooks of different witness statements. They are primarily statements that were provided by discovery given me by the people. There were then efforts by my investigators to interview some of those witnesses at various occasions, and there have been leads that have been derived from those interviews. At various times, there have been 5 different investigators working in various aspects on this case, reporting not only to my office, but to Mr. Shapiro's office as well. The normal process has been that duplicate copies of all investigative reports be submitted both to Mr. Shapiro's office and to our office as well. The normal process has been that I have worked very closely with Ms. Sarah Kaplan, Mr. Shapiro's office, mutually coordinating different discovery, mutually coordinating the preparation of different defense witness lists, and comparing what items would comply with the different aspects of discovery consistent with our interpretation of our obligation under the Discovery Act. I am prepared at this time because there has now been what I hope is a final search of all names that were on our witness list, not only on the recent witness list, but also on the list that was prepared in August of 1994. And we went through each of those 16 books, Your Honor, and we went through and pulled any defense reports. And this afternoon I had Ms. Kaplan compare all of the reports that were sifted through and taken out of my notebooks with those documents that have been previously provided to the people. I have a stack of not a stack, I have probably 12 reports, 13 including the report of Ms. Gertjes. I will represent to the court as an officer of this court that Ms. Gertjes' statement I see for the first time only 5 minutes ago. It is a copy of a statement that was taken July of 1994. Your Honor, I acknowledge and I anticipate that there will be strenuous efforts to impugn both my personal integrity and the integrity of the defense team. I tell this court, looking the court straight in the eye with all seriousness, that it has been an oversight and I am embarrassed by it and I take full responsibility. It is my obligation as the coordinator of the evidence to be better on top of the witness flow and the preparation of statements and reports. It is my blame and my blame alone, and I take full responsibility. I am reminded by Mr. Cochran that Ms. Gertjes is an individual whom the people have been aware of because, as is at least our understanding, Ms. Gertjes had contacted both the police department and the district attorney's office. However, Your Honor, I accept responsibility because her name was added to our list in in August. There was a statement that was taken apparently from an investigator who we do not work hand in hand with each day. It does not excuse it, Your Honor, and I seek not to excuse it. I am only offering as an explanation. I am providing today the statement of Mary Ann Gertjes, and that is a statement that is signed by her, fully within both the spirit and the letter of the Discovery Act, fully a document that we were obliged to turn over in August of 1994. I am also turning over a statement of Ms. Michelle Abdul-Dran, which is dated June 24th of 1994. This is a second statement that should have been turned over in August. But she is an individual, Your Honor, who is the former maid of Mr. Simpson, who was struck by Nicole Brown Simpson, who they are fully aware of. They have been interviewing different witnesses about the incidents and the circumstances giving rise to Ms. Brown Simpson striking Michelle Abdul-Dran. So they are aware of her existence.
All right, Mr. Douglas, would you spell the name for me, please?
Sure, Your Honor. Abudraham. I am turning over, Your Honor, a statement of a Rachel Berman, who was an 8-year-old, who accompanied the Simpson children and Nicole Brown Simpson, a person whom they are aware of. She accompanied them to Ben & Jerry's, if you will, and she accompanied them to Mezzaluna. She is an 8-year-old. Her name was given only this Monday on our supplemental witness list.
What's the date of that statement?
That statement is June the 20th, 1994, Your Honor. Her mother's name has been on our witness list. The statement of the mother was earlier given. We decided only this week to call the child or to add the child on our witness list. I am turning over a statement dated July 31 or dated August the 1st concerning a July 31 interview of an Alex Castillo, whom Ms. Kaplan informs me was not previously turned over.
And what is Mr. Castillo's relevance?
Mr. Castillo was an employee at Mezzaluna Restaurant. And he gives testimony or information concerning a supplemental report by Detective Tom Lang suggesting that he had given Mr. Goldman a beeper and denying same. I am turning over an August 2, 19...
Let me just clarify, is this the Brentwood, Metzaluna, Beverly Hills?
That's correct, Your Honor.
Oh, which
Oh,
one?
this is the Brentwood Metzaluna.
All right, thank you.
I'm sorry. I am turning over a statement of Naradine, N-A-R-I-N-D-E-N, Singh, S-I-N-G-H. Mr. Singh is the owner of a newsstand across the street from Metzaluna. He is on our witness list. It is simply talking about the existence of a video camera at his newsstand. He is on the witness list as just a precaution.
What is the date of that statement?
August the 2nd, 1994. I am turning over a report for Kevin Whelan, W-H-E-L-A-N. The report is dated August the 3rd, 1994. He works as a dispatcher with Network Courier Services, who speaks about a courier having called the dispatch and saying that the courier had obtained an autograph of O.J. Simpson on June the 12th, 1994 at 11:20 p.m. And the statement is, "You'll never guess whose autograph I got? O.J.'s." I am turning over a statement, Your Honor, dated July 14th, 1994, of a Tony Parker. As the court will recall, I did not know on Monday who Tony Parker was. As the court will further recall, I turned to Ms. Kaplan and she didn't know who he was. This is a statement that comes from one of our investigators. Mr. Parker is the owner of a white 1973 International Scout four-wheel drive, which was parked on Bundy north of Darlington on June the 11th through June the 13th, 1994. I am turning over, Your Honor, a 2-page document given from Mark Partridge. Mr. Partridge is the
lawyer referred to by Mr.
correct, Your Honor,
Cochran.
dated June 27, 1994, and there's a fax cover sheet dated June 25, 1994. I am turning over a report from Miss Rosita Rubin, R-H-E-U-B-A-N, dated August 23rd, 1994. She is connected with Rubin Motors, which was one of the impound yards, I think, that is involved in this case concerning A.C. Cowlings' Bronco.
What's the date of that?
August the 23rd, 1994. I am turning over another report for Paul Soneshine, S-O-N-E-N-S-H-I-N-E, dated August 16th, 1994, concerning an interview that he had. He is an employee of Rubin's impound yard. And he talks about the fact that Mr. Cowlings' Bronco was left in an unsecured location. I am turning a report over dated July 20, 1994, of Mr. Thomas Tellerino, T-A-L-E-R-I-N-O, who talks about the fact that he was roller skating on June the 12th, 1994, on Bundy, and he sees a man hiding in the bushes near 877 South Bundy, who was not the defendant. I am turning over a report of Mr. Ronald Taylor, dated June 22, 1994, who resides in Chicago, who said that Mr. Taylor had occasion on June 13th to see O.J. Simpson. When Mr. Simpson arrived in Chicago, that he shook his hands, exchanged a few pleasantries, observed his hands, and did not see any scratches or cuts, and how Mr. Simpson was very friendly and gracious but appeared tired from the flight. I am turning over a report dated July 19, 1994, from Mr. Jason Wood, who apparently worked for Air Touch Cellular located in Irvine. and who happened to call Mr. Simpson on his cellular phone on June 17, 1994. I am also turning over a report of a Mr. Joel Pitkoff, Pitcoff, dated August 24th, 1994. Mr. Pitkoff is a research and analyst manager of the Ford Motor Company, and this is the report testifying or stating that for the 10-month period from October 93 through July 94, 26,688 Ford Broncos were sold nationally. 20,012 were sold in the first 7 months of 1994.
How many white ones?
Your Honor, this report does not break down the number of white ones.
Okay.
And those are the statements that I can say now with a stronger degree of confidence are all statements that are discoverable, that are obligated to be turned over. As I say, Your Honor, I take full responsibility for any failures to have fully complied before now.
Mr. Douglas, how do you suggest I deal with the objections that I'm going to hear from the prosecution as soon as I finish peeling them off the ceiling?
I suspect, Your Honor, that the best way to deal with these objections is, one, to strongly admonish the defense, as you probably will do. I think a second appropriate objection would be that when we get to the defendant's case, which will be likely in 2 months, if not longer, that you ask the people for the status of their investigative efforts as to these particular witnesses. That if the people can make a showing that they have failed or been unable to fully complete any investigation as to any of these individuals after having 2 months or more to do so, that we be required to call these witnesses towards the end of our case. I think that that would be a sanction that would be more consistent with the sanction that was earlier imposed on the prosecutor, but I think that my learned colleague might have some other thoughts in that regard.
Your Honor, one voice.
Yep.
Clear issue.
Yep. Do you want to change court reporters at this point? Janet? Mike?
As I said earlier, Your Honor, since January the 1st of this year, I have been responsible for coordinating the evidence, for making sure that discovery has been fully complied with. Certainly, this turning over of documents today reflects a breach in the process. It is one that predates my current role, but one that I accept responsibility for because somebody has. I think, however, Your Honor, that when you take the totality of the circumstances, given the scope and the mountain of evidence in this case, given the number of witnesses on both individuals' witnesses lists, given the time and the care and the effort that has obviously been placed into this case by both sides, that the court should fashion any sanction, if at all, that is measured, that is consistent with the court's knowledge that these are lawyers who don't play games, who don't play fast and loose with the rules, who perhaps both sides have made mistakes and errors. I see Mr. Darden smiling, but both sides have made mistakes. We are all human. I am not perfect, but there is no bad faith, and I am surprised as anyone that there were these numbers of documents that had not been turned over previously.
I have to say, Mr. Douglas, I've had long experience with Mr. Hodgman. I've known him as a colleague and as a trial lawyer, and I've never seen the expressions on his face that I've seen today. Mr. Hodgman, why don't you take a few deep breaths and then we'll take a look at this. But I have to tell you that my suggestion to you is going to be as follows. This is a rather wide range of witnesses who cover a rather wide range of topics and a wide range of issues. And I have to deal with these each individually because they're each in a different posture. One or two of these might be justified in an explanation deciding to add them on the witness list and turn over the statement after, say, for example, the court's rulings on domestic violence. Some of these others, though, clearly go to whodunit issues. Say, for example, Tollerino, who was roller skating on Bundy that evening. Obviously, that's a different posture. I'm going to suggest to you that you go over this list, go over those individual statements which you have, which I'm not privy to, and see which ones, what sanctions you seek as to which delay in discovery, and present that to me in the morning.
Your Honor, I'm going to ask for a little bit more. You know, it was considered by this court this morning to have the resumption of televised coverage of this case. The court's interest, as I'm sure at least certain parties, was that this would be an opportunity for America, law students, law professors, and perhaps even people around the world to see how the system operates in America. I am sorry to say that we have a horrible breakdown. And while I appreciate Mr. Douglas falling on his sword this afternoon, I think he minimizes the consequences and the depth of what has occurred here today. Your Honor, if the people, on the day of opening statement were to unload discovery dated June, July, August of this year, I can only imagine that the sanctions against the people would be severe. I don't intend to minimize this, and I encourage the court, do not minimize this at all. Your Honor, it is not only what was turned over this afternoon, which we will need time, and perhaps more than overnight, to examine. We are going to have to go through this and evaluate it in light of other evidence.
I understand that, Mr. Hodgman. That's why I was suggesting that perhaps you ought to take the time, carefully evaluate what you have there, and if you want to come back on another day on Thursday or Friday to argue the issue of sanctions, we can take it up then. I'm just offering that opportunity to you because I think that would be a more efficient way to deal with it.
Well, I agree that some time in order for us to evaluate would be a more efficient way to deal with it. But, Your Honor, we do not want to proceed with evidence until we've had not only an opportunity to view this discovery, but the remaining items that have been alluded to in Mr. Cochran's opening statement. I can go through a laundry list right now, but, Your Honor, I hope this is a file. This, up until today, this is the extent of the defense discovery to the people. Under California law, there's supposed to be reciprocal discovery. That's part of playing fair. That's part of playing the game fair. The people have been severely prejudiced today, Your Honor, severely prejudiced. This conduct is outrageous and unbelievable. Now, in Mr. Cochran's statement this afternoon, we have reference to statements from Joe Stellini, Howard Weitzman, Skip Taft, Ron Fitchman. We have a number of witnesses like that. On top of that, we have a myriad of representations as to the defendant's physical condition with regard to dyslexia. Where is the report? Arthritis of several different varieties. Where are the reports? An expert regarding shoes. Where are the reports? Potential evidence regarding tire tracks. Where are the reports? The cut on his finger. He intends to present expert testimony. He said it this afternoon with regard to the nature of that cut and a possibility of where the defendant got it. Where is the report? Mr. Cochran refers to other photos, apparently other than what have been disclosed to the people. Where are the photos? He talks about having an expert testify that trauma on Ron Goldman's hand is consistent with a certain scenario. Where are the reports? We have all sorts of test results apparently conducted by the defense that have not been forthcoming. We have reference to Ms. Walker, who has been giving information to the defense. I realize she's just recently retained, but Mr. Cochran is referring to findings, to data, to other material that have not been disclosed to the people. We have reference to testimony of Dr. Bodden and Dr. Lee. Where are the reports? The people don't have them, Your Honor. This is supposed to be a fair proceeding. Where are the reports? There are witness statements which have been given to us which have redactions. We're going to be asking the court for a hearing with regard to the nature of the redactions so we can determine whether or not it was proper to even have those redactions. Your Honor, there is a myriad of issues that have been raised by the acts of the defense today, an absolute myriad of issues. The people need some time to digest this. I realize this comes at a difficult time in the proceedings, but I don't think in the history of jurisprudence have we ever had anything occur like what happened today in this courtroom.
All right, Mr. Douglas, would you address the additional issues that Mr. Hodgman raises that...
Certainly, Your Honor. Your Honor, with all due respect to Mr. Hodgman, and he is a colleague whom I respect, he has never practiced law as a defense lawyer under Prop 115. There's a new way to practice law these days, and that way is, since reports are discoverable, Your Honor, reports are not automatically written. Perhaps the way that he's accustomed, whenever you talk to a doctor writes a report and turns it over, and then it's discoverable. Your Honor, when I talk to Michael Bodden, and Michael Bodden gives me some ideas for an opening statement or talks about what is his theory of the case, we are not doing it writing faxes back and forth. We talk over the telephone and we present evidence. Mr. Cochran has been trying cases for 33 years. He doesn't need to have a report in order to say something in an opening statement. I can call Howard Weitzman, who is a colleague of mine on another case, and ask him, Mr. Weitzman, did they tell you to leave the room in that interview? And he said yes. And can I call you as a witness? And he says yes. And there is no report. I can talk to my client about a dear, dear friend, Joe Stellini, and say, what would Joe Stellini say? And he will tell me that Joe Stellini said that there was nothing going on, and I put his name on the witness list, and there is no report. Your Honor, I will fall on my sword, but I object to the insinuation that I am doing something untoward. I acknowledge, Your Honor, that I am not perfect. I acknowledge, Your Honor, that I have done something wrong. I stand before this court chaste, and I acknowledge that. But I have been a lawyer for 15 years, and I take my obligation seriously, and I take the accusations of the people very seriously. I do not practice law that way. I acknowledge when I'm wrong, but there has not been any maliciousness. This is not the most preposterous thing in jurisprudence. This is a mistake. This is a function of dealing with hundreds of witnesses and going to trial in 7 months. This is a function of there being 12 lawyers, 5 investigators, 22,000 pages of evidence. These are slips through the proverbial crack. I accept it and I acknowledge it, but I object strongly to any impugning of my integrity or the integrity of any lawyers on this team. Thank you.
Mr. Hodgman, how would you suggest we proceed at this point? Since the ball seems to be in your court, you're the aggrieved party, how do you want to proceed?
I am the aggrieved party. Well, I am not, Your Honor. The people are.
You represent the aggrieved party.
I certainly do, and the people are deeply aggrieved. Your Honor, first of all, we will provide to the court a case that says the defense cannot circumvent discovery laws in the manner suggested by Mr. Douglas. There is a case on point. We will provide it to the court. We'll let the case speak for itself. As far as Mr. Douglas
Well, that was
goes...
part of my, you expect me to believe that comment from the day before.
I'm sorry?
Never mind.
Oh, in fact, I recall, yes, Your Honor. Yes, I think the court is familiar with the case. Your Honor, how do we proceed? We don't proceed at this point because we need an opportunity to deal with what has been unloaded on us.
Counsel, what we are doing, we are breaking early today because of the juror's obligation. Let me suggest that we do this. Do take the evening hours to examine what has been presented to you. Do prepare whatever letter brief you feel is appropriate. Obviously, fax a copy to counsel. I think some of these witnesses, obviously, for example, the Berman child, I think you're aware of, because I recall seeing something about that somewhere in the. Some of these things may not be egregious errors of discovery. Some of them may be very fundamental problems for the people's case that you may not feel comfortable going forward without having some substantial investigation done. I understand that. But what I'm asking you to do is take a few deep breaths, evaluate what you have, evaluate the record from today, and then come to me with a proposal as to how we proceed tomorrow morning.
Your Honor,
I just think it would be a more efficient way to do this.
we will do that. What concerns me is what we don't have, what we have not been given. The court is familiar with the law. The court, a couple days ago, stated, you expect me to believe that. Now, Your Honor, this is just a question of fundamental fairness, and fundamental fairness for the people. The people, too. We have
Mr. Hodgman, I agree. I understand the point you're making. And what I'm suggesting to you is that in a coherent, witness by witness, item by item, you determine what your position is. Because the sanctions for failure or delay in discovery are oftentimes very severe. And if you recall in our discussion from yesterday or the day before, your first position was preclusion, which is the last step the court can take after having exhausted all lesser remedies. So I want you to be very careful about how you do that, because if I preclude something and the Court of Appeal or somebody else decides that I've abused my discretion, oftentimes that's reversible error. And there are enough landmines in this case already. So let me suggest that that course of action to you.
Your Honor, in addition to what the court suggests, we will review Mr. Cochran's statement this afternoon.
I understood that that was part of your comment.
Very well, because we will be asking for an order that any such reports be produced, and forthwith.
Which is why you have the real time, and I suspect you may unplug your computer and take it home with you tonight.
It may be a long time before I get home tonight, Your Honor. Your Honor, we will do as you suggest. We will report back in the morning. I expect it's going to be a very long night. I also anticipate...
Long night. They're all long nights, Mr. Hodgman.
Well, they are, but this one's going to be especially long. And, Your Honor, before we can proceed any further, we need to evaluate this, and we need, well, Your Honor, like I said, a Pandora's box of discovery issues has just been cracked open this afternoon. We're going to need time to evaluate.
All right, counsel, just as a precaution, I'm going to direct Deputy Magnera to have the jury brought over at 10 rather than 9, so we at least have a running start to look at these issues and see how we frame them.
I appreciate the court's optimism. 10 o'clock may be early, but
I'm
we
always
will do it.
optimistic. You know.
I know, Your Honor.
All right. All right, any comment from Mr. Cochran, Mr. Shapiro on the discovery issue? Mr. Douglas, I'm sorry, you're the discovery sword man. All right. We will stand in recess as far as counsel are concerned until 9 o'clock. And Ms. Childs, can I see you, please? Ms. Childs. All right. I was unaware of that.
Press conference this afternoon concerning the reason for her involvement in this case. The court should be aware of that because it's a questionable ethics and conduct, and I think that I thought it should be brought to the court's attention.
Well, that person is not presently within the jurisdiction of the court, so I don't know that there's anything I can do about that, or would be inclined to at this point. All right, well, thank you for advising me.
To this defense counsel's witness, perhaps the court would like to advise defense counsel of the advisability of a press conference of that nature, but perhaps not. I just thought you should know.
Thank you. All right, thank you, counsel.